In this petition, my lord, petition, affidavit has been filed yesterday, my lord.
Okay.
And we'll file reply, my lord. Some time may be granted.
Filed by whom?
Filed by respondent number 2 and 3, my lord.
Mr. PJ Saikia, the counsel for the petitioner. Press for
10 days time, 2 weeks time.
2 weeks time to file reply to the counter affidavit filed by the respondents. 2 and 3.
My lord.
Praise the Lord.
Obliged.
After 2 weeks.
My lord, I am praying for listing of a matter, my lord, pensionary benefits, my lord.
Ah.
Any day for admission, my lord.
What?
Court. Obliged.
My lord, this matter relates to correction of date of birth, my lord. May be listed on 27th for admission, my lord.
Why 27?
My lord, it's pending since.
Is it already filed?
2023. Yes, my lord, it is to
But-
be listed for admission.
When was it last listed?
It was last listed on 11/12/23, my lord.
11th or
Yes, ma'am.
29th?
May I please have a look? Sir, with the consent of others, I have to mention item number 23, 24, 25, 26.
Huh?
Hearing better, my lord.
23 to 26.
26, my lord.
Ah.
Lordship may taken up on next Tuesday, my lord, on 26, my lord. Because in this matter, my lord, Mr. P.N. Soma appeared, my lord.
Hmm.
So due to
Who is the petitioner's counsel? Okay, heard Mr. B.D. Baral and the counsel for the petition. On request made on behalf of Mr. B.N. Sharma and the standing counsel
elementary,
elementary.
my lord.
List the matter when?
26, my lord.
26.
26.
Coming Tuesday.
26, there are many cases. If you want to try your luck, is a different.
Because of the fact that 26,
Or the third would be a better date.
it will be too long because it is listed in the last on the lordship direction 3 occasion. It is
Oh,
regarding the retirement benefit for the years together.
we'll have it on third.
Thursday.
Yeah.
Yes.
Witness, third December, Tuesday is the hearing,
Yes.
third.
Obliged, my lord.
Please, Your Lordship. I beg to mention a 2017 contempt petition
Oh,
for you for listing, Your Lordship, as per Your Lordship's convenience.
okay, second.
2nd December, Your Lordship. I'm great.
May I please, Lordship, with consent of respondent counsel, beg to mention item 14, Lordship.
Item
14, Lordship.
Okay.
Matter will be taken up after a week, Lordship.
after 1 week.
Monday, Lordship.
On behalf of A.R. Bhuyan.
Yes, Lordship.
On request made on behalf of Mr. A.R. Bhuyan. and the counsel for the petition. List the-
All day, Lordship.
May I please, my lordship, I beg to mention item number 13, lordship. Can this matter fix on 25th?
13.
Yes, lordship.
Yes, my lord, I'm for the petitioner, my lord. This is a declaration of the result by the Guwahati University.
Third, Mr. D. Gogoi and the counsel for the petition. You are appearing on behalf of?
TJ Fukan, Learned Standing Council of Guwahati.
On request made on behalf of P.G. Fukan and the standing counsel Guwahati University. When do you want?
On 25th.
25th.
Next week, there are many cases.
Then lordship,
We can have it on Monday, 2nd.
And my lord, if it can be Friday, my lord. 29th, my lord, if it's possible, my lord.
Okay, thank you.
May I plead, Your Lordship?
Yes.
I beg to mention list of admission matter on next Thursday, my lord.
Oh.
28th, my lord.
Okay.
May I please, Your Lordship? My lord, I am praying for listing a case, my lord. 25th, my lord.
6. 6.
May I please, Lordship? Lordship, I beg to mention for listing it for admission, Lordship. On 29th, Lordship, it is possible, Lordship.
6.
Obliged, Lordship.
May it be please, Your Lordship, with the consent of the other side, Lordship, I beg to mention item number 2, Lordship. Matter may be fixed on 26th, Lordship. In this case, Lordship, Mr. Avani Deka will argue and he is out of station, Lordship.
Who?
To item number 2, Lordship.
Who's arguing the matter?
Avani Deka, A Deka, Lordship.
A Deka.
Yes, Lordship.
Okay, on request made on behalf of A. Dekal and the counsel for the petition. When do you want?
26 Lordship.
26 is. Okay, 26.
Interim is there, Lordship, interim shall
The order postulate and continue till the next sitting.
apply.
I will listen, Lordship, kindly allow this matter for listing on Monday, Lordship. Earlier I mentioned for listing allow, but not listed yet, Lordship.
What is it about?
Lordship,
It's a motion matter.
admission matter, Lordship.
When was it last listed?
16/8
27.
of list.
May I please your lordship, I beg to mention for listing. Lordship, there is a two matter, contempt matter, lordship. Any date,
What?
lordship.
27 of supplementary list, withdrawal.
Yes.
My lord, liberty may be given, lordship. There is a latest development, lordship.
Okay, Mr.
Yes, Ali.
S. Ali, Leonard counsel for the petitioner, press for withdrawal of this petition. With liberty to file a petition. I must speed us, standing counsel, press for the secondary education department.
Obliged.
Dismissed and withdraw with liberty as per.
One of daily list, admission, Parker.
No total completed. My lord, my part was completed. My
On the last occasion, Lordship, it was decided that it was heard long time ago.
Yeah.
So Lordship would like to hear the others.
Can you just recapitulate it a little bit?
very well.
I am also new entrant, so I would also like to know what
Okay,
exactly
okay.
was their argument.
Right.
In fact, my lord, I had placed the list of dates that must should be in the record, my lord.
Yes, sir. Yes.
My lord, this is against an order of removal from service as professor, Department of Foreign Languages, Guwahati University, after a my lord disciplinary proceeding. Now, my lord, the grievance of the petitioner is that, my lord, this order of my lord removal has been challenged. There are, my lord, three orders. The first order is, my lord, at page 168. It's not good. Yeah. Petitioner copy to लिया गया. Beautiful law. May I read that order, my lord?
Yes.
This is a my lord, letter from the registrar to the petitioner. With reference to the above, referring to an earlier order, it is hereby informed that the Executive Council of the Guwahati University, in its meeting held on 5/10/2021, after careful consideration of the findings of the report of the inquiry officer dated 10/9/2021, in connection with the DP drawn up against you, has resolved to impose upon you the penalty of removal from service, which shall not be a disqualification for future employment as per Rule 7(6) of the Assam Service Disciplinary and Appeal Rules with immediate effect. As such, you are hereby removed from service of Professor, Department of Foreign Languages, Guwahati University with immediate effect. This is issued with the approval of the Honorable Vice Chancellor, Guwahati University, dated 6/10/2021. Now, my lord, the other order is at, my lord, page 34,
3-4.
34. Sorry, my lord. Ivan over, sorry, my lord, I have made this statement at, my lord, para 34. Paragraph 34 of the writ petition at page 22.
Yes.
May I read it, my lord?
Yeah.
So I'm trying to give a, my lord, brief facts about the, my lord, giving an overall picture. That it is pertinent to state that the memorandum of charge sheet dated 22/6/2021 issued to the petitioner was not even placed before the disciplinary authority for its approval. It is further stated that the minutes of the Executive Council meeting held on 8/6/2021 and 12/7/2021 nowhere reflects that the charge memo was placed before the Executive Council and was approved by the Executive Council. Thus, the charge sheet dated 22/6/2021 was not placed and approved by the disciplinary authority before it was issued to the petitioner, and the approval of the charge sheet by the disciplinary authority before the same is issued is a mandatory requirement under the law. This is my lord. First, my lord, the leg of the, my lord, on which, my lord, I am challenging the order of removal. The petitioner begs to state that the charge memo having not been approved by the disciplinary authority is non-est in the eye of law, and therefore all the consequential proceedings initiated on the basis of such charge memo is also not maintainable in the eye of law. It is also apposite to state that the charge memo was issued after appointment of the inquiry officer in gross violation of the existing rules. Now, your lordship may like to see the charge memo that your lordship finds at page 55.
Before reply to the
May I read it? Memorandum, this is dated 22nd of June 2021. The Vice Chancellor, being Chairman of the Executive Council, Guwahati University, proposes to hold an inquiry against Dr. Kandapa Das with the petitioner. The then Director, G.U. Idol, under Rule 11 of the Guwahati University Teachers Conduct Rules 1984, read with Rule 7 and 8 of the Assam Services Discipline and Appeal Rules 1964. The substance of the imputation of misconduct or misbehavior in respect of which the inquiry is proposed to be held is set out in the enclosed statement of articles of charge, Annex 1. A statement of the imputation of misconduct or misbehavior in support of each article of charge is enclosed. A list of documents by which a list of witnesses by whom the articles are proposed to be sustained are also enclosed. Dr. Controveras, for the purpose of preparing his defense, my lord, these are the normal things. My lord, your lordship may see the allegations against him. Next page. Page 56. Article 1. The said Dr. Kandapa Das, while functioning as Director, Guidol, tenure 2006 to 31st January 2016, had started and ran 21 unapproved courses and which continued during the period 2010 to 17 as observed in CAG report, which constitutes violation of Rule 4 of the Guwahati University Teachers Conduct Rules. Article 2, that the Dr. Kandapa Das, while functioning as Director Guidol, tenure 2006 to 31/1/2016, during 2010 to 17, continued the above unapproved courses in spite of his having knowledge of the mandatory requirement of approval of the courses by the Distance Education Council, UGC. This constitutes violation of Rule 4 of the Guwahati University Teachers Conduct Rules. Article 3, Though the approval from DEC UGC was necessary to run the courses in Idol, appropriate steps were not taken by Dr. Das when he was then director of GUIDL for 2010-17. This constitutes violation of Rule 4. Article 4, as many as 73,912 students were enrolled and passed out on completion of alleged unapproved courses during the period 2010-11 to 2016-17, making them ineligible for central government services, thereby threatening their future employability. In spite of being well aware of the deficiency, Dr. Das, who was director during his period, allowed the courses to run. This constitutes violation of Rule 4 of the rules. Article 5, DEC, UGC were unaware of the running of such alleged 21 unapproved courses by GUIDL during this long period of 7 years. Dr. Das, as head of IDOL, during the period failed to intimate DEC, UGC appropriately, which constitutes violation of Rule 4 of the Guwahati University rules. Article 6, though well laid down procedures were prescribed or in existence for getting approval of courses offered by GUIDL from DEC, UGC, the same was not followed properly by Dr. Das, and his decision of continuing the unapproved courses is not justified. This constitutes violation. Article 7, the irregularities committed by IDOL authority under Dr. Das by running the unapproved courses resulted in avoidable expenditure. Then my last statement of imputations are there. This, my lord, your lordship may not read at this stage. So these are the allegations, the basic allegation against him that, my lord, a course was running and the Distance Education Council and UGC did not, the approval was not there. So that is the, my lord, basic allegation against him. Now, there was an inquiry, my lord. The petitioner, my lord, he filed his written statement of defense and a regular proceeding was initiated. The inquiry report, your lordship finds at page 81.
81.
Right.
Is this what date?
Inquiry report is, my lord, date is, my lord, date to
21/9/2020.
This is, my lord, 10/9/2021. Your lordship finds at the bottom, my lord.
Okay.
Handwritten. এটা পড়িন জানো হ্যাঁ বহুত ভুল ভুল এগুলো এটা তো পড়িন Now, your lordship may kindly take up the list of dates, my lord. That will be important. I'll show the documents. My lord, your lordship will kindly note the dates because, my lord, the inquiry officer was appointed prior to, my lord, filing the written statement. Your lordship knows the procedure, my lord, the statement of allegations, that is the charge that is filed to the, my lord, served on the delinquent. Then, my lord, he gives a reply. The authorities are to consider his reply. Thereafter, the authorities will decide whether the reply is acceptable or not. Then, if the authority is not satisfied that the reply is acceptable, then only, my lord, it is decided to hold an inquiry. Then an inquiry officer is appointed, and my lord, presenting officer or my lord, defense assistant, all these. My lord. Here, my lord, the inquiry officer was appointed before, my lord, before filing of the written statement. Your lordship will kindly see the dates I have given, my lord. Now, this postgraduate correspondence school, of which the petitioner was the director, my lord, he joined as the director on 19/8/2006. Your lordship will see the, my lord, third date in the list of dates. The postgraduate correspondence school was established in the year 1998. And the, my lord, executive council decided to create a post of full-time director in 2005. And then, my lord, the petitioner was appointed on 19/8/2006. Then, my lord, that's postgraduate correspondence school was, my lord, renamed as Guwahati University Distance and Open Learning Guwahati University, GUIDOL. In short, my lord, they say IDOL. On 18/11/2011, my lord, the petitioner 5 years term he, my lord, completed. Then on completion of the term, he joined back as professor of the, my lord, Department of Foreign Languages, but he was given, my lord, additional charge. So, my lord, for 5 years, my lord, he has served sincerely. Although, my lord, he had completed his term, thereafter, although he joined back as professor, he was also given the, my lord, additional charge. That shows that, my lord, there was no, my lord, unsatisfactory, my lord, that his service was not satisfactory to the authorities. Then in 2013, my lord, after 2 years, he was again appointed as director of IDOL. Then 2016, my lord, that 5 years, the second 5-year term was also complete. The petitioner was released from the post of director, and the petitioner, my lord, came back as professor of the Department of Foreign Languages. Then what happened, my lord? In 2019, the Comptroller and Auditor General submitted a report on social general economic matter sector for the year ended 31/3/2018 before the State Assembly. Thereafter, the said report was forwarded to the Guwahati University by the state government. Then, my lord, the university gave a reply. I'm sorry, my lord. University gave a reply regarding the, my lord, CAG observation, and whatever was, my lord, there, my lord, expressing a little displeasure, that was, my lord, replied to by the university, which, my lord, stand they have subsequently changed. Then, my lord, on receipt of the CAG report, the Executive Council of the Guwahati University decided to constitute an inquiry commission headed by Dr. Justice Aftab Hussain Saikia to inquire into the anomalies indicated in the report of the Comptroller and Auditor General. Then, my lord, the term of reference of the inquiry commission was notified on 6/12/2019. Then, in the meantime, my lord, the petitioner was appointed as Vice Chancellor of KK Handy State Open University. The commission submitted its report before the Guwahati University containing various recommendations. That is in 2020, after, my lord, he left the university, Guwahati University, and joined as, my lord, Vice Chancellor of KK Handy State Open University. On 31/3/2021, report submitted by the committee constituted by the Executive Council on recommendation of Saikia Commission. Then this date is important, my lord, 8/6/2021. The Executive Council decided to appoint Pallav Bhattacharjee as inquiry officer. On that date, my lord, even charge sheet was not issued against the petition. So they decided to hold the inquiry. Inquiry officer was appointed, and the inquiry officer on the, my lord, on 17/6/2021, he has accepted the offer of the Guwahati, of the, my lord, University Authority. Now, charge sheet is, my lord, that order. Your lordship may like to see that order, my lord.
Yes.
Page 52. This is very important, my lord. Page 52. This is issued by the Registrar Guwahati University, addressed to one Sri Pallav Bhattacharya, IPS, retired, former chairman, Assam Public Service Commission. The date is very important, my lord, 10/6/2021. Respected sir, greetings from the Guwahati University. With due regard, the undersigned as directed is pleased to apprise that your name has been suggested to conduct a departmental proceeding as follow-up action and forward your recommendations as per relevant rules of the university consequent upon the submission of Dr. Justice Aftab H. Saikia Commission report against Professor Kandarpa Das, who happened to be the director of Guwahati University Institute of Distance and Open Learning from 2006 to 2016, of which 6 years and 1 month falls under the period of inquiry. covered by the report of CAG. As such, you are requested to accept the offer. You will be paid suitable honorarium for your activities on the days of visits to the university. So and so a copy of Dr. Z's commission is enclosed as per relevant decision of the Education Council. The matter is to be concluded within a month. Enquiry officer appointed, charge sheet not issued, and the enquiry officer has been directed to complete the enquiry within a month. Then your lordship may kindly come to page 54. Date is, my lord, 17/6/2021. The enquiry officer, my lord, he writes this to the registrar of the university. Sir, in inviting a reference to the above, I'd like to convey my acceptance to conduct the departmental proceeding against Dr. Das, the then director, pursuant to the commission report. I would like to request you to send me the following documents. So, my lord, the enquiry officer has accepted without there being, my lord, initiation of a disciplinary proceeding. Now, page 55, that is the, my lord, memorandum 22nd June 2021, my lord. This is the charge sheet. So, my lord, enquiry officer was appointed on 10/6/2021. The enquiry officer accepts the appointment on 17/6/2021. And, my lord, on 26 June 2021, the charge sheet is issued. My lord, I'll show your lordship that this is in violation of the rules. And also, my lord, there are decisions of the Honorable Supreme Court. I have placed, my lord. I'll just refresh your lordship's memory on that, my lord. So far as the rule is concerned, my lord, rule is, my lord, Assam Service Disciplinary Appeal Rules 1964. The procedure for, my lord, imposing penalties, Rule 9. Everything is predetermined. Only thing, my lord, they want to show that we have followed the procedure. Rule 9, your lordship may kindly read, my lord. Although
Guwahati University follows this?
Yes. Yes, my lord. The charge sheet is under, my lord, Guwahati University rules and the, my lord, Assam Service Disciplinary Appeal Rules 1964 that your lordship will find.
Okay, yes.
My lord, in the charge sheet itself, my lord, they have said paragraph 5, my lord. Paragraph 5 of the charge sheet dated 22nd June 2021, Dr. Das is further informed that he does not submit the written statement of defense before the as specified so-and-so does not appear in person. The inquiring authority or otherwise falls refuse to comply with the provisions of the Assam Service Disciplinary Appeal Rules 1964 and other order directions. So, madam, this is under these rules. Therefore, in the matter first part of the certificate. In the, my lord, first paragraph also they say that. Although, my lord, your lordship has read these procedures, my lord, quite a number of times. Even then, my lord, your lordship will allow me to read. Procedure for imposing penalties. Without prejudice to the provisions of the Public Servants Inquiry Act 1950, no order imposing on a government servant any of the penalties specified in Rule 7 shall be passed except after an inquiry held as far as may be in the manner hereinafter provided. The disciplinary authority shall frame definite charges on the basis of the allegations on which the inquiry is proposed to be held. Such charges, together with a statement of allegations on which they are based, shall be communicated in writing to the government servant, and he shall be required to submit within such time as may be specified by the disciplinary authority a written statement of his defense and also to state whether he desires to be heard in person. Then your lordship, my lord, may skip the explanation, come to sub-rule 4. On receipt of the written statement of defense, or if no such statement is received within the time specified, the disciplinary authority may itself inquire into such charge as are not admitted, or if it is considered necessary so to do, appoint for the purpose a board of inquiry or an inquiry office. So, my lord, charge sheet comes first, then, my lord, written statement, then, my lord, the question of appointing or not appointing an inquiry officer or inquiry committee. This has been, my lord, violated. Now, my lord, the petitioner filed his written statement of defense on 28/6/2021. He was placed under suspension from the post of Vice Chancellor, KK Henry University. Then, my lord, 10/9/2021, the inquiry officer submits his report, and it was, my lord, accepted by the Executive Council. And thereafter, my lord, after acceptance, your lordship will see everything, my lord, at every stage, my lord, the cart is before the horse. The petitioner was, my lord, the report of the inquiry officer, your lordship will find in the list of dates, 20th of September 2021. September 2021, the report of the inquiry officer was accepted by the Executive Council. They accept it, and thereafter, my lord, on 21/9/2021, the petitioner was directed to submit his comments on the inquiry report. My lord, the ideal situation is that, my lord, the report has to be, my lord, sent to the delinquent. Then, my lord, before the Executive Council, there has to be two documents. One is the, my lord, report of the inquiry officer, and, my lord, the representation of the delinquent against the, my lord, report of the inquiry officer. Thereafter, my lord, they take a decision. But here, my lord, they have already accepted the report of the inquiry officer. Now, my lord, I'd like to draw your lordship's attention to, my lord, page 38 of the writ petition, the stand of the, my lord, university earlier. Running up on page 38. In fact, my lord, this is a part of the, my lord, report of the commission, my lord, Justice Saikia Commission.
Oh.
That starts at page 35.
No, it is a CAG report.
CAG report, my lord. Okay. I'm sorry, CAG report. The report of the Guwahati University on the CAG report. Now, my lord, this is the, my lord, report of the Guwahati University on the, my lord, CAG report. There, my lord, it has given a, my lord, it's given its stand against the, my lord, report of the CAG. Now, this is, my lord, your lordship may come to page 38, my lord. This is, my lord, issued by the registrar at that point of time. He is the present Vice Chancellor of the Guwahati University. I'm reading B, my lord. Such legal opinions appeared to be treated as comments, and accordingly, Professor Nanigopal Mohanto, the then registrar, sent a communication dated 18/1/2019 to the Joint Secretary of the Government of Assam Higher Education Department, enclosing the above opinion and by way of comments, and the same is reflected below. So this is the stand of the Guwahati University, my lord, much prior, that is in 2019. Later, reference number such and such from Professor Nanigopal Mohanto, confidential. From Nanigopal Mohanto to the Joint Secretary to the Government of Assam Higher Education Department. Comments on the draft para in CAG's audit report. Madam, with reference to your letter above, we enclose our comments. Now, this is the stand of the Guwahati University at that point of time. Comments of the Guwahati University on draft para in CAG's audit report, unapproved courses offered by the idol Guwahati University. That is the allegation, my lord. Unapproved courses were being run. Although it was, my lord, started much prior to this petitioner joining as director, but during his tenure also, my lord, that approval from the Distance Education Council and UGC did not come. Now, your lordship, one is a long report. I'll draw your lordship's attention to, my lord, page 41. The concluding paragraph of the report, my lord. Page 41, second paragraph. From the aforesaid, it is seen that with effect from 31/8/2007, provisional recognition was given to all courses of the Guwahati University to offer such courses in the distance education mode, and such provisional recognition continued till 3/8/2010. On 4/8/2010, recognition was accorded to 8 courses and the authorities of Idol Guwahati University bona fide believed that the courses which were left out in the letter dated 4/8/2010 was due to some inadvertent mistake, and the same would be recognized in due course, this course of time, and on such anticipation that the recognition would be granted, the authorities had continued to offer the said courses in distance education mode. However, the same have been discontinued with effect from the academic year 2017-18. Further, till date, no complaint and or case has been filed by any student who had undergone the courses alleging that the courses offered has not been recognized by any employer, or that any organization has refused to recognize the said courses, meaning thereby that all such courses have been duly recognized by various employers' authorities. Any fee collected has gone to the accounts of the Guwahati University, and there is no personal involvement of anyone. It is respectfully stated that it was a bona fide error of judgment on the part of the authorities of Idol, and there was no ill mention on anybody's part. Therefore, the explanation put forward may kindly be accepted and the matter may be closed. So this was the my lord stand at the university in 2019. So my lord, error of judgment, your lordship knows, my lord. This will not constitute, my lord, a misconduct on the part of my lord. That is one of the points, my lord, I'll argue. Now, my lord, so far as the inquiry report is concerned, the petitioner has also filed his reply to that, response to that. That was not considered at all. Now, my lord, the most important point, one of the most important point is that, my lord, the charge sheet, the charge memo, which was issued to the petitioner, that was not approved by the, my lord, the Executive Council. It would reflect it. Yes. I'm trying to be brief, my lord, because perhaps, my lord, by this time your lordship will remember what I have made my very elaborate submission. I don't want to take as much time now. If necessary, my lord, in the reply, I'll say that, but I'll like to draw your lordship attention that, my lord, in the inquiry report, there is a note of dissent. That is important, my lord. There was a note of dissent, my lord, that the procedure was not followed. Your lordship may kindly, my lord, pick up. This is there in the, my lord, additional affidavit, but this will be compilation handy, my lord, in the compilation. Page 104. 104A. 104A, my. This is written by Dr. Hemanta Kumar Sharma, my lord, professor, Department of Mathematics, who is one of the, my lord, DC members. He addressed this letter to the, my lord, registrar of the, and my lord, ex officio secretary of the Executive Council. Justification of my note of dissent against the acceptance of the report by EC, Guwahati University, which was submitted by Mr. Pallab Bhattacharya of Guwahati University. There, sir, in the EC meeting of Guwahati University dated 20th September 2021, I argued verbally against the acceptance of the report mentioned in the subject by the EC, GU, and requested the authority to record my note of dissent against the decision of acceptance of the report of the EC, Guwahati University. Now I am sending my arguments in writing and request you to ascertain my note of dissent in the minutes of the proceedings of the said meeting. My arguments are as follows. Number one, Professor Dr. Das joined as director in August 2006 and left the directorship on January 2016. The present inquiry was held for finding and fixing responsibility for continuation of unapproved courses of idol during 2010 to 17. Till now, there is no answer regarding who is responsible for the continuation of the unapproved courses for the period between January 2016, when Professor Das left the director post, till 2017. I feel without finding out this, the inquiry will be incomplete and perverse. Because, my lord, if the course was continued, that continued, my lord, prior to his joining and after his joining also. It is now, my lord, only the petitioner has been singled out. Number two, Professor Das joined the director of IDOL on August 19, 2006. The PGCS used to run 14 subjects at that time. When the letter from the DEC IGNOU was received on 4/8/2010 by the then VC informing about the approval of only 8 PG courses, IDOL was offering 24 courses at that time. After completion of the first term of 5 years in the post of director IDOL starting from 2006, Professor Das was appointed for a second term by the Guwahati University Authority. I feel the decision was taken looking at the efficiency, sincerity, etc. of Professor Das. Before putting the blame entirely on Professor Kandarpa Das as the director IDOL GU, the duties and responsibilities bestowed on him as the director should be looked into. While creating the post of director of IDOL by the Executive Council in its meeting dated 29/10/2005 by resolution number such and such, it was resolved that it will be manned by a full-time director in the rank of professor. The meeting further resolved that the administrative and financial control of the PGCS will be under the Vice Chancellor. So, my lord, it's not only the director, he is only, my lord, he has to act under the instructions of the Vice Chancellor. The above resolution clarified that the VC is duty-bound to know all the administrative and financial details of the institute. Moreover, had Professor Das not carried out the orders of the VC, he could have been charged with disobedience towards his higher authority. There was no communication like that, my lord. Introduction of new courses. Admission to any of the courses of the IDOL is regulated by the statutory provisions of the Guwahati University Act. The same has been substantiated by a written statement of Dr. Midul Hazarika, the former Vice Chancellor of the Guwahati University, to Mr. K.K. Sharma, Secretary in the Department of Higher Education, Government of India, on 3/8/2017. Dr. Hazarika wrote, prior to and after obtaining institutional recognition, GU IDOL introduced several master's degree courses and diploma programs by following the established Guwahati University statutory procedure. A core committee or an advisory board was always there since its inception, in which VC was the chairman and the registrar, controller, and academic registrar, treasurer, etc. were other members of the committee or the board. Every action was carried out according to the resolution taken in the committee. So, my lord, there is a committee headed by the Vice Chancellor. Then your lordship may skip, my lord, one paragraph. Then in the fourth resolution of 18/5/2009 of the core committee, when late Professor O.K. Medhi, the then Vice Chancellor, was on chair, the committee resolved as follows. The core committee resolved to introduce MA in Nepali from next academic session. The core committee also resolved to introduce MCA, MSc IT, and AmTech IT from the academic session 2009-10 and accept the recommendation of the management committee for the IT courses regarding detailed fee structure, study center, and fee sharing arrangements with study centers. In the second resolution, the advisory board, when Dr. Midul Hazarika, the then Vice Chancellor, was on chair, the board resolved as follows. As the process of admission to different program is getting delayed due to non-receipt of approval communication from the UGC DEC, it should be DEC. The board resolved that admission to offered courses should start immediately for the greater interest of the students. Then in the third resolution of the same meeting, the board resolved as follows. In case any of the action of the UGC DEB on matters of program offered by the IDOL, which might affect the future of the students seeking admission to IDOL of those already enrolled, as also the people of the state at large, the board authorizes the university to take appropriate measures of appeal to the UGC-DB petitioning the MHRD Government of India through appropriate authority as well to seek legal remedies if necessary. So this was in, my lord, 2016. Then, my lord, if your lordship kindly comes to the next page, my lord, paragraph 7, referring to a letter, my lord, written by the, my lord, the Vice Chancellor Gunani Gopal Mahanta, that is quoted, my lord. The quotation portion I want to read. The letter mentioned, the authorities of Idol GU bona fide believed that the courses which were left out in the letter dated 4/8/2010 by UGC to the VC GU was due to some inadvertent mistake, and the same would be recognized in due course of time, and on such anticipation that the recognition would be granted, the authorities had continued to offer the said courses in distance education mode. However, the same have been discontinued with effect from academic year 2017. Further till date, no complaint and or case has been filed by any of the students. My lord, all the students have been employed, my lord. There is no complaint. It's not that, my lord, their employability was, my lord, questioned by any authority or any university, any employer. So, my lord, I'm not reading this. So this was, my lord, according to them, an error of judgment. And it is, my lord, very clear from the dissenting note that, my lord, it's not only the petitioner who is responsible for taking the decision. There is a committee headed by the Vice Chancellor, and everything is done, my lord, under the, my lord, guidance of the committee and the Vice Chancellor, but the petitioner was singled out. Only one paragraph I'd like to read from here, my lord, again at page 104D, my lord, clause 9. We are investigating a procedural lapse as confirmed by the EC committee, and I feel in the process we ourselves should not create our procedural lapses during the course of taking the final decision. So, my lord, the allegation is regarding a procedural lapse, and, my lord, in inquiring it, my lord, they are again, my lord, committing the procedural, my lord, lapses. As far my knowledge about the disciplinary procedure of Assam government, charge sheet should be framed and approved by the disciplinary authority, in this case the EC of the Guwahati University, and served upon the charged officer, in this case Professor Dr. Das. After getting reply from the charged officer within the specified time, the disciplinary authority itself can investigate the same on the basis of the charge sheet and the reply, or can employ some inquiry officer, presenting officer to the same on behalf of the disciplinary authority. In the present case, the inquiry officer was employed on 10/6/2021, following the decision of the EC on 8/6/2021, that is much before the charges were framed, and served on the charged officer on 22/6/2021. Myself as EC member, I have not seen that either the charges were framed by the EC or even it was approved by the EC. So, my lord, from this dissent note itself, my lord, it is clear the above procedural lapse is a serious one, and I feel it's a violation of the principle of natural justice and rule 9. Now, my lord, now the picture is very clear, my lord, from this dissent note itself, that, my lord, a charge sheet was framed, which was not approved by the Executive Council. Before the charge sheet was framed, an inquiry officer was appointed, and, my lord, inquiry officer accepted the report. And thereafter only, my lord, the charge sheet was my lord, issued, and that is also, my lord, not approved by the Executive Council. So these are the, my lord, basic facts on which I am challenging the order of removal. Now, my lord, I relied on certain decisions. The most important decision is, my lord, B.V. Gopinath. I have given this in the, my lord, in the compilation. 2014 1 SCC 351, Union of India versus B.V. Gopinath. Your lordship finds that at page 105 of the compilation. 108. The relevant paragraph, your lordship will find at page 108, my lord. Paragraph 2, my lord, the issue.
Oh, no.
The central issue that arises for consideration in these appeals is whether the charge sheet issued against the respondent is without jurisdiction in view of the fact that the disciplinary authority, that is the finance minister, had not given approval for issuing the charge memo, even though he has given approval for initiation of major penalty proceedings against the respondent. Now, your lordship will see, my lord, the petitioner's case stands on a much better footing than this, because here is a case, my lord, where the finance minister did not, my lord, give the approval to the, my lord, charge memo, but then, my lord, he had approved the initiation of major penalty. So, in our case, my lord, there was no discussion on that. So, my lord, the law that has been laid down by the Honorable Supreme Court in this case, my lord, your lordship, I'll not read the, my lord, entire judgment or page 121. Your lordship may kindly come to page 121. अच्छा, वो तो 49, 49. 49 to अच्छा, वो तो कोई नहीं. It has been summed up in page paragraph 49. Although number of collateral issues had been raised by the learned counsel for the appellants as well as the respondents, we deem it appropriate not to opine on the same in view of the conclusion that the charge sheet memo having not been approved by the disciplinary authority was honest in the eye of law. So, if it is not approved, charge sheet is not approved by the disciplinary authority, in this case, the executive council, this is honest in the eye of law. So, on this ground alone, my lord, the petition requires to be allowed. There is another decision at page 122, my lord, 2018 Supreme SC 841. It is, my lord, 2018 17 SCC 677. State of Tamil Nadu versus Pramod Kumar, IPS. So BB Gopinath has been followed. My lord, it has been followed in a number of all my lord subsequent decisions that if the charge sheet is not approved by the disciplinary authority, the charge sheet is honest in the eye of law. Therefore, my lord, the entire proceeding, my lord, falls true. Paragraph 19 at page 130, my lord. It is also settled law that if the rule requires something to be done in a particular manner, it should be done either in the same manner or not at all. That is, my lord, Taylor versus Taylor, 1871, my lord, that has been received, 1875, that has been relied. In view of the mandatory requirement of Rule 84 and the charge memo being drawn up or powers to be drawn up by the disciplinary authority is not complied with, we are of the considered opinion that there is no reason to interfere with the judgment of the High Court on the issue. The only addition we'd like to make is to give liberty to the disciplinary authority to issue a charge. So there are other decisions, my lord. Page 132. Your lordship may come to page 132, my lord. Union of India versus Union of India versus J. Ahmed, reported in, my lord, 1979, 2 SCC 286. The relevant paragraph will be, my lord, paragraph 11. Paragraph 11, my lord, only I'd like to read at page 137. Code of conduct as set out in the conduct rules clearly indicates that the conduct expected of a member of the service. It would follow that the conduct which is blameworthy for the government servant in the context of conduct rules would be misconduct. If a servant conducts himself in a way inconsistent with the due and faithful discharge of his duty in service, it is a misconduct. A disregard of an essential condition of the contract of service may constitute misconduct. Then, my lord, the High Court has noted the definition of misconduct. Then your lordship will kindly read my lord, Misconduct means misconduct arising from ill motive, act of negligence, error of judgment, or innocent mistake do not constitute error of judgment. So, my lord, error of judgment does not constitute misconduct. It is a stand of the government. I'm a Guwahati University. That, my lord, that was a bona fide mistake and it was an error of judgment. If it is an error of judgment and petitioner is not the only person, my lord, who has committed that error, it has been committed by his earlier director and the subsequent director. He has been singled out. And my lord, even if my lord that is the stand of the university earlier, that my lord it is an error of judgment. My lord, it is not a misconduct because he has been, my lord, removed from service on the allegation of misconduct. And the, my lord, running of the course, this, my lord, distance education courses, this is taken by the Guwahati University Academic Council, Executive Council and Academic Council. And the, my lord, the director either has to carry out, my lord, whatever is the, my lord, directed by the committee. And this director, my lord, he is not a member of the Executive Council or the Academic Council. And therefore, my lord, he does not have any say in the, my lord, action that has to be taken by the, my lord, the Academic Council, Executive Council, the Vice Chancellor on the committee under which, my lord, he is functioning.
Director is not a member.
Not a member. He's not a member of the Executive. In the Guwahati University Act itself, my lord, in the compilation is there. In the compilation, I have annexed that, my lord, Act. That will show, my lord, the composition of the Executive Council. Page 40. Page 40, your lordship will find that. 40.
This act.
My lord, of the act. In the compilation also, my lord, is there. Your lordship may see that.
Page?
Page 40, my lord. This starts at page 1. 40 is the, my lord, the provision regarding the Executive Council. Section 12. The Executive Council. The Executive Council shall be the executive body of the university and shall consist of the following members: the Vice Chancellor, the Rector, Director of Public Instruction, Director of Technical Education Assam, Director of Health Services, Director of Public Instruction Manipur, Director of Public Inspector Arunachal Pradesh, Chairman Board of Secondary Education. The other members are the principals of non-government affiliated degree colleges, principal of the government affiliated degree colleges, two head of the departments, then Dean of Faculty, to be chosen by the Vice Chancellor, 3 members to be elected from the court among these members. So these are the members, my lord. The director does not find place. And Academic Council, your lordship will find that, my lord, page 48. They are also, my lord, the director is not a member. So he does not have any say in the decision-making process of the, my lord, running of the IDO. Section 14 is the, my lord, Academic Council. Your lordship will find that, my lord, the director of distance education, the name does not figure there. He is not a member of the executive or Academic Council. So he is not a part of the, my lord, decision-making body. And so far as the petitioner, my lord, appointing authority is concerned, each appointing authority is the, my lord, Executive Council. Appointing authority. Who is his appointing authority? Is 46. Is 46, 13F, section 13F. This is, my lord, regarding the appointing authority. Power and duties of the Executive Council, your lordship finds at page 44, section 13. This is the powers and duties of the Executive Council. Then, my lord, at page 46, your lordship will find 13F. Shall appoint officers other than chancellor, the vice chancellor, and the rector, teachers, librarian, protocol, etc. So he's a teacher of the university, shall appoint the officers. So my lord, the appointing authority is the executive council. In fact, my lord, that your lordship will also find in the conduct rules of the Guwahati University at page 51. 53. At 53, your lordship will find that, my lord.
1 minute. Page? Page 53.
Page 53. Yes. 53, my lord. Guwahati University Teachers Conduct Rules 1984. These rules shall be called the Guwahati University Teachers Conduct Rules. Then, my lord, university means the Guwahati University. Then your lordship may come to, my lord.
1 minute.
Next page, my lord. The improper conduct, that is at my lord, clause 10. Then 5 is, my lord, every teacher 5 shall devote himself diligently to work and utilize his time to service of the university and the course to conduct a full cooperation all and other activities connected to the welfare of the student community. Then, my lord, the improper conduct your lordship will find at clause 10. The following lapses shall constitute improper conduct. Then, my lord, sub 5. The refusal to carry out the decision and orders of the appropriate administrative academic bodies and or functionaries of the university, this will not inhibit his right to express his difference with their policies or decisions. So, my lord, there is no allegation that, my lord, he has refused to, my lord, carry out any of the decisions of the authority, which has, my lord, my lord, decision making. In fact, my lord, whatever has been decided by them, that has been followed by the petitioner as the director. One last thing I'd like to, my lord, draw your lordship's attention to is, my lord, your lordship will get it in the compilation, my lord. That is a part of, it starts that, my lord, this is the report of the committee constituted by the Executive Council. It starts at page 63. The report of the committee constituted by the Executive Council by the resolution number such and such. A committee was constituted by the Executive Council, Guwahati University, by this resolution number such and such to examine and recommend the submission made by the director who served during the period 2010 to 17 in connection with the commission report. Now, my lord, the committee comprises of, my lord, 4 persons, 4 Executive Council members. So, my lord, the report, that report, my lord, that pertains to not only the petitioner, it in respect of other persons also, my lord, they were there. I think your lordship will see that at page 65, the observation and recommendations. Clause 4 at page 65. This is, my lord, one of the observations and recommendations. It is observed that Professor Das, who was the director for about 6 years during the period of inquiry, that is 2000 to 17, 10 to 17, and also prior to that from 2006, committed certain procedural lapses. Many of his communications to the DEC were made but directly without a copy either to the vice chancellor or registrar. Being the director, it was his responsibility to inform the Guwahati University authorities from time to time about the recognition, non-recognition of the courses. As director of IDOL, he could have taken initiative to discontinue admission of the unapproved courses. He also did not make any effort to get directions from the higher authorities regarding admission in unrecognized courses, which continued for several years during his tenure. These are evident from the relevant records and his submissions. In spite of several procedural lapses, as mentioned above, it is pertinent to note that no effort was spared by Dr. Das in getting the recognition of the unapproved courses from these. So, my lord, it has already, my lord, taken note of the fact that, my lord, he has made, my lord, taken all the steps. No effort was spared by Dr. Das in getting recognition. But this is the, my lord, observation of the committee comprising of 4 members of the executive. In spite of that, my lord, it was decided to hold an inquiry. Then, my lord, the charge sheet was framed. Then the charge sheet was not approved by the executive council. Then, my lord, the inquiry was conducted. I'll not, my lord, read the inquiry officer's report at this stage. It's a very long report. If necessary, they may reply, my lord. I may point out what are the flaws of the, my lord, inquiry officer's report, my lord, because it has been already been determined. Everything is predetermined that this person has to be, my lord, penalized. Now, so far as that perversity in the, my lord, inquiry proceeding, that is one aspect where, my your lordship, while my lord, scrutinizing a disciplinary authority, that perversity is also an important factor. But I'll not argue that at this stage, because, my lord, my first submission and the, my lord, the strongest point is that, my lord, without approval of the charge sheet by the executive council, the, my lord, charge sheet is known as in the IOP. And my lord, the inquiry of appointment of my inquiry officer, putting the, my lord, cart before the horse at every step. And thirdly, my lord, it is the stand of the university that, my lord, it was a bona fide error, not only of the petitioner, but, my lord, the entire authorities, part of the authority, different parts of the authority. Hmm? In fact, there is another decision, my lord, I had placed that. That is also in the, my lord. That is also.
What was your third point?
First point is that, my lord.
No approval.
No approval. No approval by the disciplinary authority, the, my lord, executive council of the charge sheet, and therefore that is known as in the IOP.
Inquiry officer appointed prior to.
That is the my second.
Your third one is.
Third is that, my lord, it is the stand of the university that it was a bona fide error, and, my lord, that does not constitute misconduct. On that, my lord, the Supreme Court decision I have already placed, my lord. If necessary, I'll reiterate that. Then, my lord, on perversity, my lord, I may submit, my lord, if necessary, my lord, at the. Because, my lord, if your lordship holds that the first point, that then, my lord, your lordship need not go into the perversity part. But if I need to argue on the perversity part, I'll argue that, my lord, if necessary. Otherwise, my lord, I have to take your lordship to the entire report of the inquiry officer. And, my lord, there is a divisional decision of the Rajasthan High Court, solely, my lord, exactly similar to the present petitioner's case. That also I have placed, my lord. If necessary, I'll want to reiterate. That is 2000. Well, I have given a photocopy. It's already there, my lord.
This one.
It's already there, my lord.
In the compilation, no.
No. It's not in the compilation, my lord. An extra.
Seema Jain versus Rajasthan High Court. Rajasthan High Court.
My lord. That is exactly on the point, my lord. Seema Jain versus Rajasthan High Court. The relevant paragraphs will be, my lord, paragraph 53. I'll provide another copy, my lord.
No, that thing is not here.
I'm providing another. There, my lord, same thing, paragraph 53, 60, 62, and 64. These are the, my lord, 4 paragraphs.
Paragraph 53.
Paragraph 63, then my lord, 53, my lord, 53, then 60, then 62, and my lord, 64. This covers my lord, my first and second point of argument. And there is a fourth point, my lord, that the my lord, rules have been violated. Assam Services disciplinary rules.
Rule 9.
My lord, that has been violated. These are the 4 points, my lord. Primarily, accept perversity. That, my lord, if required, my lord, I'll argue. If your lordship accept this points, my lord, then perhaps your lordship need not go into that. Obliged, my lord. In this case, I'm going to make an unusual player, but before that, I'd like to place the affidavit filed by Guwahati University. Because my learned friend has argued quite in depth. So it will be very much essential if lordship is pleased to come to paragraph 4, then paragraph 6, paragraph 5 also, then 6, 7, 8, all paragraphs, lordship, our affidavit, we have stated that the deponent craves leave of this honorable court to refer to and rely upon the relevant documents as and when required. So I am a new entrant in this case, and my whole team is new. If I have to, because to counter whatever submissions they have made, I have to rely upon lordship. The most important is the commission report of Justice Aftab Hussain Saikia's commission's report. That is number 1. Various resolutions passed by the EC committee. That is number 2. Number 3, the inquiry report and the findings of this. Number 3. So I have gathered all these documents, but the relevant pages are not a part of the affidavit. So my humble submission, that's why I made a submission. I'll make an unusual player. Let lordship hear me on Thursday next. By Monday or Tuesday, we'll file an additional affidavit by annexing the relevant pages of all these documents. Because the writ petition also has not enclosed those documents, and we have also not done it. And it will be totally, this honorable court will be handicapped to know the correct picture, to throw light exactly what happened. What was this, whatever my learned friend, senior friend is now submitting is totally contrary to the statements made by him before Justice Saikia's commission. Totally different. Why I am telling it? Because this same gentleman was appointed as Vice Chancellor of KK Hendik Open University. There also he made the same mistake, continuing 15 unrecognized courses, allowing only 8. And he was also dismissed from service as a Vice Chancellor. It's a unique case. So that's why I have read through all those documents. In the earlier case, I represented the KK Hendik University. A Vice Chancellor has been here, he's a director. But as a Vice Chancellor also, he lost his job. And there is no challenge to his dismissal. So my humble submission, lordship will kindly allow me, because no injustice should be done to him also, because if I refer to all these pages, if I give a photocopy also, they will not have a copy. Later on this ground only, they will challenge before the higher court. It should have been a part of this affidavit. I deeply seek lordship's apology that it was not done properly. But
that is a rectifiable, curable mistake on our part because the affidavit ought to have. There's a reference, but the pages are not there. So only 3 days by Monday, Tuesday we'll file it, and Thursday next, Lordship, because the memory will be afresh, Lordship. I do not want to delay this matter also. But to counter all his arguments, I need to take support of these documents, especially the statements made by the gentleman before the commission. And the 2 points, Lordship, that appointment of the inquiry officer, all these things, I have the documents here. He was subsequently appointed, not prior. The offer letter is considered as an appointment letter by the other side. He was appointed on 1st July, not on 10th of June. That was an offer letter given to Pallav Kumar Bhattacharya, seeking his approval whether you are agreeing to our offer or not. He gave a reply on 17th, accepting the offer. Then on 1st of July, 2021, he was appointed. That appointment order later we have annexed. Lordship may take the affidavit, the last page. Annexary page 26. What the other side is saying that he was appointed on 10th of June, at least 20 days earlier. From H.K. Nath to Pallav Bhattacharya, appointment as inquiry officer, greetings from Guwahati University. In response to the written statement dated so-and-so received from Kondorpal Kumar Das. In response to the charge sheet dated so-and-so of 26, it is felt that an inquiry has to be conducted on that matter. As such, as per relevant Executive Council resolution, you are hereby appointed as inquiry officer.
Where are you reading from?
Page 26, annexer
Of
E
your affidavit?
of the affidavit filed by Guwahati University.
Page 26.
The internal page 26, I do not know the exact numbering of Lordship's record. The last page of the affidavit. Filed by
last page.
Last page, Lordship. Filed by respondent number 23456. This is the actual appointment order. What the other side is saying.
Last page is something else.
Lordship, annexer E. D is 10-6, which they are relying and referring to as an appointment order.
Your affidavit is annexure 1, 2, 3, 4, 5.
My affidavit, Lordship, of Guwahati University. It is page 25 and 26. Annexer D and annexer E.
Okay, there are 2 affidavits.
Then additional affidavit was also given.
One affidavit is a small affidavit.
That is not a little bit thicker. The date is of the affidavit is, Lordship. It was filed on 4th of January 2022. By Dr. Hemanta Kumar Nath.
Additional affidavit. This is one additional affidavit filed by petitioner. Then affidavit in opposition. 4th January 2022. Is that the one? No.
That is the one.
4th January.
4th January, Lordship. In 7-8 paragraph, there is reference that documents will be relied upon as and when required. And Lordship will kindly come to the last 2 annexers. Annexer D, 10-6. Here the second paragraph, Lordship. As such, you are requested to accept the offer. So this was an offer letter. And to that, he has accepted. That letter is also there relying. 17. Now, Lordship will kindly come to the next page, 1-7. Second paragraph, as such, as per relevant EC Council resolution, you are hereby appointed as inquiry officer to complete the departmental proceedings against Professor Kondorpal Das. So his appointment was subsequent, not prior. So that is only one issue. This will cleanse that issue, but there are a lot of other issues which the other side is now raising, or they were raising also earlier, and we have also reverted, but not with all the documents, which should have been a part of the affidavit. At least the Justice Saikia Commission's report. That is very important. That is the main basis. And what was his statement before that Judicial Commission? Those statements should be a part of it, Lord, because he himself admitted everything, and it was his responsibility.
Then let him file his
My
affidavit.
lord, I will not oppose to my learned reference prayer, my lord. But the only thing I want to clarify, my lord, he was not dismissed from my lord KK Hindi University. He was placed under suspension by the governor on the allegations which is there in this petition, and thereafter, my lord, he has submitted his resignation and resignation was accepted. It was not a dismissal, and the allegation is anyway, my lord. That will be besides the point.
But
But
Mr.
let him take the time. shorter
M.K.
time.
Chaudhary, Learned Senior Counsel, assisted by Mr. T. Chakrabarty, Learned Counsel for the petition. On request, Mr. D. Saikia, Learned Senior Counsel. You'll be as a Senior Counsel or
Yes,
AG?
as a senior counsel.
Senior Counsel assisted by P.G. Fukan, Learned Standing Counsel, Guwahati University. Praised for a short time to enable him to file an additional affidavit, placing on record certain documents which should have a bearing in the present writ petition stuff. The prayers allowed. List the matter for further hearing on, when do you want? Thursday next.
If it is convenient for this honorable 20th or on 3rd of December.
It's your convenience.
3rd of December, Lordship. 3rd of December.
Lord, if they file it a little earlier, if necessary, my lord, we may have to respond. I do not.
I will file it by 28th.
That will
Actually,
be fine.
till 27th, I am not here from tomorrow.
Then third it will come, but the copy will
we
be
will give
provided
early
to us.
copy.
Okay, list the matter on 3rd.
Deeply obliged, Lordship.
If Martin and Martin is apart, we will, huh?
I'm very slow for 5 minutes. Okay, on request made by Mr. S.P. Chaudhary and the counsel for the petitioner. When do you want?
First
5th.
in admission law.
Yeah, 5th December. Oh, it can come on any day.
First week of December, yes, it's a fourth, I think this
On 4th
4th of December
in
in
the
admission.
admission call.
Obliged.
3, admission.
These are the matters, my lord, where my senior, my lord, Mr. P.K. Mohanta had argued, senior advocate, regarding those matters where we had made them undergo a second medical board once they already had a certificate of a particular disability. Going through the records, I found that there is already a repetition which was dismissed by a coordinate bench of the Honorable Court, my lord.
Same.
The issue was exactly the same. They were subjected to a second medical. Now, what I'm told is that there was a writ appeal. Writ appeal was not entertained. Perhaps it has gone back for a review. The review status we have not been able to find out from the website. That is one. As of today, matters stands settled by.
That would be important.
That will be a very important aspect of the matter. Second, my lord, I will not be relying much on the facts of the case because that has been argued well enough. They had a certificate. They applied for a what do you say, selection process. They were sent back to a second medical, and then they were found not to be having that much of disability. I will be only referring to judgments of the Honorable Supreme Court, one of the Orissa High Court. Exactly.
But
this
they are present. Are they present?
Suppose they were there in the morning. Their timing is what?
Just let them come. Because see, that judgment is there. I'd like to have a look at this judgment.
Yes. The judgment copy was handed over, my lord, on the last occasion. It was given.
Was it handed over?
Yes.
Huh? The judgment was handed over. Oh, Banita Das.
Bhanita Das.
Oh.
12/6/2024. From the time I senior APS matter, perhaps we can just go through the judgment matter. I'll read it out.
Was it handed over by you?
Yes, we gave it.
Did you furnish a copy?
It's in that. And they have a copy.
You've got a copy of this.
Bhanita Das also. Prohibit you understand what this judgment said.
So you're relying on this judgment?
But it will have an impact on the entire issue. That's good. Para 3 onwards.
The judgment?
Yes, the Bhanita Das.
Yes.
Para 3. The case of the petitioner is pursuant to a recruitment advertisement dated 25/3/2022 issued by the Secretary State Level Recruitment Commission for Class 4 posts. The petitioner had submitted her online application for filling up 13,300 numbers of vacant grade 4 posts under the category of person with benchmark disabilities. The recruitment was to be done per the Assam District Recruitment for Class 3 and Class 4 analogous post rules 2022. The petitioner had cleared the written examination held on 21/8/2022 and was declared qualified for the next level of the test. Thereafter, she had appeared in the interview. The petitioner was declared qualified as per the provisional result published by so-and-so. The provisional result of Class 4 issued by the SLRC is clearly mentioned in bold letters that in case of PWD, category appointment shall be confirmed after medical examination and clearance received from the medical board. Accordingly, she had become eligible for appointment. Subsequently, as per the randomized posting result of SLRC grade 4 that was published on 9/5/23, the petitioner was recommended for appointment in the post of Chowkidar for the establishment under the secondary education department. By virtue of notice published on 12/5/23, all the recommended candidates were asked to appear before the medical education and research department with the benchmark disability of the successful PWBD candidates. It is projected that on the appointed date and time, the petitioner had appeared and subjected herself for medical re-verification that was conducted at Guwahati Medical College and Hospital. The result of the medical re-verification was declared in newspaper on so-and-so, wherein the petitioner's name did not appear. Thereafter, by notice dated 6/6/2023 issued by the Principal Secretary, Department of Social Justice and Empowerment, all candidates with benchmark disability who did not qualify in medical re-verification were called upon to file an appeal by 16/6/2023. Accordingly, the petitioner had preferred an appeal before the Private Secretary, Department of Social Justice and Empowerment. Thereafter, by an advertisement published on so-and-so, all PWBD category candidates who had filed appeal were asked to reappear before the medical board at GMCH on the scheduled date mentioned in the notice. The petitioner again appeared before the medical board at GMCH for her medical re-examination. However, again, the name of the petitioner did not appear in the result declared on 19/8/2023, where the list of candidates who had cleared the test was notified. The petitioner then approached this court by filing a writ petition. This court, by order dated so-and-so, disposed of WPC number so-and-so, directed the respondents to communicate the individual disability status on the petitioner against the post she had applied for. The petitioner claims that on 30/4/2024, she was handed over a communication dated 8/2/2024, issued by the Joint Secretary, the Government of Assam, Department of Social Justice and Empowerment, by which her disability status was assessed by GMCH on 2/8/23 was to the effect that her hearing impairment was 14.66. The case of the petitioner is that the employment advertisement, there was no disclosure of the terms and conditions that the PWBD candidate would have to appear for medical re-verification. In this context, the learned counsel for the petitioner submitted that the process was discriminatory as candidates other than PWBD were not required to undergo a medical examination. It was submitted that disbelieving a certificate of disability for PWBD is also discriminatory. It is also submitted that as per government notification dated 13/9/23, the medical board was required to be constituted by principal cum chief superintendent of the concerned medical college for the purpose of report, and its report would be final and binding. Hence, it was submitted that the constitution of the medical board was illegal. It was further submitted that as per the disability certificate dated 8/7/2021 issued by the competent certifying authority, the petitioner was suffering from permanent hearing impairment disability and the percentage of disability is 100%. It is also submitted that instead of notifying rules within 6 months as envisaged in this section 101 of Right of Persons with Disabilities Act 2016. The state government had been following one clause 5 of the OM dated 2022, as well as another notification dated 13/9/23, whereby powers were reserved for reassessment of benchmark disability and cancelling the certificate issued by the competent authority. It was submitted that a fresh advertisement dated 27/1/23 had been used for filling up 5,000 tentative vacant class 4 posts under different departments envisaging reservation for PWBD category. Accordingly, it was submitted while issuing notice one advertised post for PWBD taken. Submissions of the state and department council have been heard upon opposing the admission of this petition and intent period made by the petitioner. The learned standing council for response number 6 has placed reliance upon the case of state of Uttar Pradesh versus Ravindra Kumar Sharma. It is not in dispute that before the petitioner was provided with an offer letter to join in service, she was asked to undergo medical re-examination. However, on such re-verification, she was not diagnosed as a person having benchmark disability. It is admitted by the petitioner that she had collected her disability status as assessed by GMCH, whereby her hearing disability was assessed as 14.66%. Be it mentioned that in para 11 of the petition, the petitioner has not assailed provisional result. Notice published on 12/5, advertisement dated 6/6, by which petitioner was asked to appear for medical verification, or notice published on 19/8 requiring the petitioner to appear for her medical re-verification. By order dated 18/12/2023, passed by this court in WPC 7232 of 23, filed by the petitioner, she was granted liberty to assail the decision of the medical board by filing a fresh petition. Thus, in the said petition, the petitioner had not assailed provisional result of Class 4, notice published on 12/5, advertisement dated 6/6, notice published on 19/8 referred to above. Hence, the court is constrained to hold that the petitioner had waived her right to challenge the constitution of the medical board. By allowing this court's order dated so and so, passed in WBC 7232 to attain finality, the petitioner had abandoned challenge to the constitution of the medical board and or to challenge provisional result, notice published, advertisement, by which the petitioner was asked to appear for medical verification, and or notice published on 19/8. Therefore, the principle of constructive res judicata could be squarely applicable in this case, and the petitioner cannot be permitted now to turn around and lay a challenge to the manner in which the medical board was constituted, which she had waived or failed to challenge in a previous petition. It is well settled that having appeared in a selection process, it is not permissible for an unsuccessful candidate to turn back and challenge the selection process. If one is authority on the point, the case of so and so, the Supreme Court of India may be referred to. I'll just pause for a moment, my lord. When the test was done or when the results were declared, in between that time, there is no agitation by the petitioners before any authority saying that we were not assessed, we were asked a few questions and let go, and then they finished the entire examination. The examination was not properly done. No assessment, no agitation at that point of time. Once the doctor comes to a conclusion that you do not have the required disability, it is then they are approaching the court saying that the process was not correctly done. We were not correctly assessed. So that part, when after the result of that particular assessment is over, it is then they say, had they come at a time saying that no, we were not even being assessed, it may be a wrong certificate, stop it at here, this is not being properly done. That was another issue of agitation. That is what the Supreme Court allows. But once you are found to have a particular result, then you say that my assessment was not correct. That is perhaps not what the Supreme Court allows. That Supreme Court says, no, that's a waiver. You waited till the results. Next, para 15. If on medical re-verification conducted by the GMCH, the percentage of hearing impairment of the petitioner is assessed at 14.66%, the petitioner cannot be said to be entitled for claiming appointment under PWBD category. It is not a case where the appropriate government, after conclusion of recruitment process, had declared certain percentage of specified disability as benchmark disability and appointed persons on pick and choose basis. Hence, it cannot be said that there is any discrimination. This court, in a series of repetition, in this court, a series of repetition have been filed by various candidates with grievance similar to that of the present petition. 5 of such repetitions are registered as such. The Understanding Council for the Health Department and SLRC has submitted that there are several other repetitions. Thus, it appears that this is not a solitary case of where, upon re-verification, the percentage of disability was not found in consonance with the disability certificate held by the unsuccessful candidates. This is important because, my lord, I'll come to a Supreme Court judgment, the Ravindra case which was referred to above, how it deals with that. Now it is dealt here. In the case of state of Uttar Pradesh Supra, the Supreme Court has observed as under. The question involved in the appeal is as to the right of the appellant to verify the disability certificates issued by the medical board under the provisions of the Person with Disabilities Equal Opportunities Act. The respondents applied for BTC training course under the physically handicapped category on the basis of certificates issued under the aforesaid rules. It was claimed that they completed the training and had been offered training in a primary schools run and managed by the state government. Complaint was received from Bharatiya Viklang Sangh of illegal usurpation of the quota reserved for handicapped persons on the basis of fraudulently procured certificates without suffering from the disability certified under the rules of 96. State government issued an order dated 3/11/2009 making a provision for constitution of fresh medical board in order to verify and assess the disability of the candidates. The candidates' question communication dated so-and-so issued by the Director of State Council for Educational Research and Training based on government order dated 3/11/2009 requiring them to appear before the medical board constituted in order to assess the disability. Out of the 234 candidates selected under the handicap category on being examined by the medical board, it was found that 21% of the candidates were not handicapped. It is apparent from the rules of 96 that disability certificates required to be issued by medical board. It can issue permanent disability certificate or the medical board shall indicate the period of validity of the certificate in case where there is a chance of variation in the degree of disability. In case of refusal of disability certificate, opportunity is required to be given to the applicant of being heard. And there can be review by the medical board on representation by the applicant and rules contain a provision to the effect that the certificate issued by the medical board shall make the person eligible to apply. It remains the same almost in the 2016 Act also. The division bench of the High Court has ignored and overlooked the material fact that verification has already been done by the medical board and it has been found that the certificates of 21% were fraudulently obtained. The High Court has issued a direction in the impugned order for physical verification of the candidate by the authorities, and in case he does not suffer from disability so certified, candidate can be subjected to fresh medical test. The High Court has overlooked that on mere physical verification, it may not be possible to know the various kind of disabilities such as that of eyes, ears, impairment, etc. That can only be done by medical examination, and particularly when the High Court itself has observed that in case there is a genuine suspicion, fraud has been committed, medical certification can be reopened. Direction issued in this regard has not been questioned by the respondents, and in fact, process of re-verification was already over when the High Court issued apposite directions. In a considered opinion, the peculiar facts of the case of such a fraud and genuine suspicion raised in the representation lost by the Viklang Sangh, and when 21% of such certificates have been found to be fraudulently obtained, there was no scope for the division bench to interfere and issue order to perpetuate fraud. Writ is to be declined in such a scenario and no equity can be claimed by the respondents. In the circumstances, we set aside the impugned judgment and order passed by the division bench and dismiss the writ petition. However, before taking any action against the individual, they shall be issued so cause in the matter and thereafter decision will be returned in accordance with law. Let the exercise be completed in so and so. Para 19 of the order of the learned single judge. Thus, in view of the above, as the disability of hearing impairment suffered by the petitioner is assessed on re-verification to be 14.66, such a disability cannot be said to be a benchmark disability. Moreover, similar to the case of Uttar Pradesh, several candidates have approached this court to assess the lesser degree of disability assessed by medical board, which is sufficient to demonstrate that the decision of the competent authority to get the disabled reassessed cannot be faulted with. The power to do such re-verification flows from OM number so-and-so, which is impugned in this writ petition. Now, in our writ petition, which we are under consideration, this particular OM perhaps is not under challenge also, which gave us the authority to go for a review medical board. Perhaps that is not under challenge. I do not know. Is it under challenge? Perhaps it is not under challenge. It may not have been in their knowledge. I am not pressing hard on that, but it is not under challenge. In this writ petition, that was also challenged. Under the facts of this case, and on considering the decision of the Supreme Court of India in the case of so-and-so, the petitioner has not been able to make out a case to sustain the challenge in the legality of the challenge to the legality of the said OM dated 21/5/2022. The court is inclined to hold the said OM to be valid. So now once the OM is valid, we have the authority to review it. On re-verification, the petitioner is not found to be suffering from benchmark disability, and yet if she is selected and appointed as grade 4 post on the strength of medical certificate showing her to be suffering from benchmark disability, then the petitioner would be infringing the right of a candidate who upon medical re-verification is found to be suffering from benchmark disability. That would be more unjust and unequitous to persons actually found on medical re-verification to be suffering from a benchmark disability. Petitioner subjected herself to the medical re-verification without any demand. After the result is unfavorable to the petitioner, she cannot be allowed to turn around and challenge the procedure adopted for selection and appointment, which was disclosed in advance in clause 8.3 of the employment advertisement dated so and so, as well as in the provisional result of class 4. The word verification appearing therein cannot be given a restrictive meaning. I'll pause here for a moment, my lord, assuming that the provisional select list that we had or the advertisement that we made did not say that we will be holding a medical review. We asked them to undergo a medical verification. That was the point of time where the challenge should have come that you do not have it in the terms of the advertisement. How can you now subject us to it? They undergo the medical review. Under what expectation? That we will pass it up. This way, that way will pass. We may have to. They allege that the process was not properly held. They do not come at that time also. They only approach this honorable court when everything goes against them. When their disability has been found at a lower, a percentage lower than what their certificates say. On the earlier occasion, I had pointed out from the Disabilities Act itself that there is a provision of penalizing persons who misuse the provisions of the act to say that I am a disabled person. They can be penalized. So there is always a scope where a man can misuse the opinion of the doctor or a certificate can be obtained. So that re-verification is something that which would be to their prejudice. It will be to actually to the benefit of the candidates that we verify every person. That is what the government has tried to do. We have done that. They have gone through it. At this is coming to say that no, you should not have done it is perhaps beyond what could have been, what can be entertained by this honorable. Para 24 is, moreover, it is no longer res integra that after the selection process is concluded, any subsequent vacancies required to be filled up by a fresh recruitment process. The new or newly available vacancies cannot be filled up from persons who had participated in an earlier selection process. Therefore, as the admitted case of the petition is that a fresh advertisement that so and so be issued to filling up so and so tentative vacant posts of class 4 under the different department, envisaging reservation for so and so. No cases made up by the petition to keep one newly advertised post under PWBD category vacant for accompanying the petitioner who has not even participated in the subsequent process. In the light of the discussion above, this revision fails and is hereby dismissed at the motion stage without issuance of notice to the respondents. That was what, my lord, this honorable court has held in one of the judgments. Now, the notification which was referred to, that notification also I had given a copy. On the last occasion, my lord, I had given a copy of the notification also. OM. My lord, yes. That OM lordship will find around clause 5 if I'm not wrong. Assam OM, yes, I've got it. Sorry. Now, if lordship would come to 5 on the next page, my lord, second page, clause 5, if lordship has, this was what was referred to. A person who wants to avail the benefits of reservation will have to submit a certificate of disability issued by a competent authority. Such certificate in the event of selection of such person for any post will be subject to such re-verification or a verification or re-verification as may be decided by the competent authority. This has been taken into account in the earlier case, Vanita Das, to say that verification will not be given a very restrictive meaning to just verify whether the certificate is issued or not. That verification would extend to having them verified for the disability. Another judgment, my lord, which I had placed before this honorable court was one of Sujata Sahu, my lord.
Yes.
Sujata Sahu. This was by the Orissa High Court. Lordship has that document. Here, lordship would have from the second, I'm sorry, from the page 5, madam. Para 1 starts at page 5. Similar questions of law. Similar questions of law and fact are involved in all the above writ petitions. All the matters were heard together. However, this court felt it appropriate to decide WPC number so and so first, and whatever the outcome of the said writ petition, the same will be covered to other similar writ petitions mentioned above. The petitioner challenges the validity of the action of the opposite parties to reduce the permanent disability of 70% issued by the medical authority to temporary disability of 30% by the State Appellate Medical Board on 15/12/2021. communicated by so-and-so and seeks a direction from this court to the opposite parties for constitution of another appellate medical board for confirmation of the disability of the petitioner. He further seeks a direction to the opposite parties to give contractual appointment to the petitioner as TGT arts in the PWD category. All these judgments which I will refer to, Lordship will find relates to the education department as teachers or as trainees to become teachers. Facts of the case. The petitioner had applied for engagement for the post of contractual TG teachers, that is graduate teachers, arts, being a PWD candidate having disability certificate of 70% permanent issued by the medical authority Kalahandi. The Director of Secondary Education Orissa had issued an advertisement dated 28/8/2021 for recruitment to the post of 10 graduate teachers, Telugu teacher in the government secondary school in the state of Orissa. Pursuant to such advertisement, the petitioner, being an eligible candidate having requisite qualification, applied for the said post under SCBC PWD category as she possessed BSc with B.Ed qualification and was also qualified under the Orissa state TET, which is not disputed by the opposite party. The petitioner had appeared for the computer-based test on so-and-so and qualified in the said test. Thereafter, the petitioner was placed in the provisional select list published by notice that so-and-so opposite party by letter that so-and-so allocated the candidates who have been provisionally selected to the concerned districts. Petitioner was posted in Sambalpur after verification of documents by District Education Office Sambalpur as per direction of the Directorate Education. The petitioner was allotted NR Nodal High School, Rengoli. Thereafter, the Director of Secondary Education Orissa by letter so published a notice directing the PW candidates selected for the post of TGT contractual to appear before the State Medical Appellate Board on 15/12/2021 as per the venue mentioned to verify genuineness of the disability. Accordingly, the petitioner appeared before the State Medical Board, where the Medical Board, after examining the permanent disability of the petitioner, came to a finding that the disability is temporary at 30%. Therefore, the petitioner filed a writ petition before this court challenging such finding of the Appellate Medical Board dated so-and-so with a prayer for direction to the opposite parties to give engagement to the petitioner as teacher contractual, being a selected candidate under PWD category as per the disability certificate, and thereby quashed the letter that so-and-so and sought for reviewing, re-examining the disability evaluation. Then, if Lordship has the paragraph 6 on the next page. Learned counsel for the petitioner submits that the State Appellate Medical Board, which was conducted at Government Boys High School for examining the case of the petitioner assisted by SCB Medical College, Cuttack, despite it was clearly directed on notification dated 21/12/21 that the PW candidates to so-and-so shall appear before Santa Bhima Bhoy Medical College. Therefore, the conducting of Appellate Medical Board of the state at Bhubaneswar is itself a clear violation of the notification dated 21/12/21. Secondly, the order of rejection dated so-and-so without considering the petitioner's grievance for reassessment of the percentage of disability in view of the order passed by this honorable court. And subsequently, some similarly situated persons like petitioners in WPC number so-and-so by order date so-and-so had the similar fate, which is completely illegal, unlawful, bad in law, and hence liable to be settled. He further strenuously argued that the petitioner will be deprived of getting the engagement in the post of contractual TGT arts, despite she has been duly selected and she has the valid disability certificate having 70% permanent disability issued by the medical authority due to the unlawful action of the opposite parties. In such circumstances, petitioner has filed the present petition. Para 8. Learned counsel for the opposite party submit that after coming into force of the Right of the Person with Disabilities Act 2016, Government of Orissa and Social Security Empowerment so-and-so of Persons with Disabilities Department passed a resolution wherein instructions have been issued regarding manner of reservation and other concessions for the person with disabilities in various posts and services under the state government or public sector undertakings. Clause 2, then the clause is given. This mandate has been followed by the department from time to time before issuance of appointment orders to the candidate. Now, Lordships would like to come to para 12 at page 7. Para 12, my lord, discussion is made. The petitioner applied for the post of contractual trained graduate teacher under physically handicapped category pursuant to advertisement dated so-and-so issued by the Director of Secondary Education as per clause 2016. As per clause 12 of the above said advertisement, a candidate selected under PWD category shall be referred to the Appellate Medical Board and only on being certified as PWD by the Appellate Medical Board shall be considered for engagement. Subsequently, after the enactment of the Right of Persons with Disability Act 16, the government of Orissa in Social Security and Empowerment of Persons with Disabilities passed a resolution wherein instructions have been issued regarding manner of reservation and other concession for persons with disabilities in various posts of the state government. Thereafter, my lord, para 13, that how to do that. Admittedly, the petitioner appeared before the Special Medical Board on so-and-so without questioning the constitution of the Special Medical Board in Unit 1 Boys High School, Bhubaneswar. However, after being assessed to have lower percentage of disability, he is raising questions over the same. Even in none of the writ petition filed before this court, they have challenged the constitution of the Special Medical Board in Unit 1 Boys High School, Bhubaneswar. However, during the course of argument, such issue has been raised vehemently. Similar issues have been dealt with by the apex court in some of the important cases and held that the High Court cannot sit as a super appellate board to review the findings of the appellate medical board, since the board is a professional body comprising experts in their respective branch of knowledge. The Supreme Court, in the case of Chairman so-and-so, Chairman Orissa Joint Entrance versus Desponton Nayak, has succinct observed that it needs no special emphasis to state that the percent of disability has to be determined by the medical board, which is specifically mentioned in the prospectus. The said board, consisting of dean and principal, SCB Medical College, Cuttack, and 2 assistant professors, Department of Ophthalmology, has assessed the disability of vision of the respondent number 1 on 16 June at 20% and issued the certificate. It noted that the certificate granted by the district headquarters, Hospital Balasur, was 40%. Court cannot assess the percentage of disability. As per the prospectus, medical board has to be constituted consisting of senior professors of the SCB Medical College and chairman or his representative under the chairmanship of the principal of SCB Medical College or his nominee. The medical board has been considered as per the norms of prospectus and it has been clearly recorded its opinion as regards the disability of vision of the respondent. In such a situation, we are constrained to hold that the High Court was not justified in interfering with the selection process in exercise of registration, declining the disability at 40% and to consider this case in the category of physically handicapped person. Approach being erroneous, order is fully updated. In the case of Ms. Devashri Mahapatra versus Union of India, the High Court of Orissa was confronted with a quite identical set of facts where the petitioner physically challenged candidate having 45% locomotor disability of right leg as per disability survey issued by the District Medical Board was denied admission into the MBBS BDS court. Of course, the disability certificate issued by the Special Medical Advisory Board stated that the petitioner had suffered disability to the extent of 10% only. Hence, she was not eligible for admission. The court observed that. Then, para 16 is the Madras High Court, 17 is the Delhi High Court, 18, my lord, is the Supreme Court judgment again. In Vidhi Himat Kataria versus State of Gujarat, Supreme Court proceeds to observe in para 17 of the judgment that when the experts in the field have opined against the petitioners, the court would not be justified in seeking over as an appellate authority against the opinion formed by the expert. In the present case, petitioner appeared before the Special Medical Board on 21 in the unit high school. It is found that there is a lower percentage of disability. Findings of the appellate board should have been attached some amount of sanctity and the candidate should have been accepted. Before parting, it is observed that the petitioner has pleaded in the repetition that in cases of persons already having permanent disability certificate, they should be examined by appellate medical board only to extent of checking the authenticity and genuineness of their certificate. Quite obviously, the same is untenable. It would be extraneous on the part of this court to direct the appointing authority to revamp its assessment criteria and procedure. Repetition of further pleas that the medical examination be done in the Maharaja Krishna Chandra Gajapati Medical College and Hospital or V. Surendra Sai Institute of Medical Sciences and so on. So the same has been dealt with, and the medical board, which has been constituted by no less an authority than the above mentioned medical college. After due examination, the medical board has opined against the petitioner's entitlement on the basis of a reviewed disability level to the post of contractual trained teacher. Then section A 58, my lord, which was read out, has been discussed. Then at para 21, my lord. Article 14 of the Constitution of India guarantees that the state shall not deny to any person equality before law or equal protection of law, but unequals cannot be treated equally. Person with severe disabilities will have to be treated on a different footing altogether. India is a party to the Convention on the Rights of Persons with Disabilities 2006. Article 18 of the said convention expects the states parties to ensure that the persons with disabilities are not deprived on the basis of disability of their ability to obtain, possess, and utilize documentation of identification. Declaration of the Rights of Disabled Persons also affirms the rights of disabled persons to services which enable them to develop their capabilities and skills to the maximum and will hasten the process of their social integration or reintegration. The need of a disabled individual to obtain identification paper and certificate of disability hardly requires special emphasis. Article 21 of the Constitution of India enshrines the fundamental right to life and liberty, and the disabled persons who are obviously entitled to rights granted under Article 21 of the Constitution of India. Accordingly, they are entitled to obtain a certificate under Section 58 of the Rights of Persons with Disabilities Act 2016 without any hassle or difficulty. The international conventions as well as the status governing their rights spell out barrier-free access of rights and services without obtaining the certificate mentioned above. The disabled will be denied access to certain fundamental rights and facilities. Consequently, they cannot lead a quality life. When the state has thought of reassessment of disability by an appellate medical board, it has to be borne in mind that the need of sensitivity and expected societal responsiveness is very important. A disabled person is entitled to receive special treatment. Under the constitutional framework, the state has to have policies for such categories of people. Article 41 of the Constitution of India casts a duty on the state to make effective provisions for securing inter alia the rights of the disabled and those suffering from other infirmities within the limits of economic capacity and development. It is imperative that the authorities look into the real grievance of the disabled people, as that is the constitutional and statutory command. The state has to play the role of loco parentis and show its concern to redress the grievances in proper perspective. In the present case, petitioner was assessed to have 40% temporary disability by an appellate medical board, which is staggeringly different from the assessment done by the District Medical Authority, Kalahandi. Petitioner was assessed to have 70% disability by the District Medical Authority, following which he submitted a certificate to the post of trained graduate teacher. This anomaly portrays a different picture altogether. Any court is expected to confine the scope of discussion as well as direction as to what the facts of a particular case demands. One is not supposed to paint a canvas larger than what is required. This court has therefore consciously restrained itself in holding that the State Appellate Medical Board shall conduct disability reassessment and make necessary arrangement for videography of the same. However, videography of the assessment procedure would not only aid in digitalization of databases, but also can act as evidence when the concerned procedure is challenged by an aggrieved person on grounds of fairness and appropriateness. Appeal medical board is required to be equipped with such videography facility. In the para 27, my lord, in the light of the above factual metrics, in the absence of any legal or enforceable right on the part of the petitioner, this court is not inclined to entertain the writ petition. Accordingly, the writ petition stands dismissed. No order as to post. Uttar Pradesh was, Rashid would like to go to the Supreme Court judgment of Ravindra that we have given, that also copy was given. That is 2016 4 SCC 791. 2016, madam.
That is not here.
It was 2016. Huh? It did.
One, yes. Yes. It is here.
Madam.
1 minute.
Is State of Uttar Pradesh against State of Uttar Pradesh and others versus Ravinder Kumar Sharma. Starts at page 792, the third page, second page. Okay. Judgment of this court was delivered by so and so. Leave granted. The question involved in the appeal is as to the right of the appellant to verify the disability certificates issued by the medical board under the provisions of the person with disabilities equal opportunities rules 1996, the respondents applied for PTC training course under the physically handicapped category on the basis of certificates issued under the aforesaid rules. It was claimed that they completed the training and had been offered appointment in the primary schools run and managed by the state government. A complaint was received from Bharatiya Viklang Sangh of illegal usurpation of quota reserved for handicapped persons on the basis of fraudulently procured certificates without suffering from the disability certified under the rules of 1996. Then Lordship would find at paragraph 3. A single bench of the High Court of Allahabad by judgment and order dated 2010 dismissed the re-replication, holding that under the rule framed in exercise of the powers under subsection so and so, the general eligibility to apply for facilities, concessions, and benefits admissible under the scheme of the Act is subject to such conditions as the state government may impose, and the state government has imposed a condition that in the order dated 3/11/2009 of Constitution of Medical Board for verification of disability, even otherwise under the rules, there can be a review of the decision upon representation by the applicant and fresh order can be passed. Thus, the certificate issued is not final. On appeal being preferred, a division bench of the High Court of Allahabad by the impugned order has allowed the appeal and has held that while the certificate has been issued in accordance with the rules, roving inquiry cannot be made until and unless fraud has been detected. It is not permissible to reopen medical certification carried out under the rules of 96. However, the High Court has directed that a physical verification may be made, and if the candidate has not been issued certificate of disability or otherwise, and he does not suffer from any disability, so certified which entitles him to such a certificate, in that event the candidate can be subject to fresh medical test and not otherwise. Accordingly, the directions of the government in the order dated 3/11/2009 and by the Director for Physical Verification be construed in the aforesaid manner. It is apparent from the rules of 96 that a disability certificate is required to be issued by the medical board. It can issue permanent disability certificate, or the medical board shall indicate the period of validity of the certificate in the case where there is a chance of variation in the degree of disability. In case of refusal of disability certificate, an opportunity is required to be given to the applicant of being heard, and there can be review by medical board on representation by the applicant, and rules contain provision to the effect that the certificate issued by the medical board shall make a person eligible to apply. In the facts of the instant case, there was a serious complaint lodged by the Viklang Sangh of illegal usurpation of the quota reserved for specially able by a large number of persons who are not in fact specially able or have procured certificates fraudulently from their districts under the rule of 96. On the basis of the said complaint, the government had issued an order for purpose of verification of such certificate issued by the medical board, and certificates of 21% of the selected candidates of the handicap category were found to be fraudulent. It is settled proposition of law that fraud vitiates, and in such a case when a large number of candidates have been illegally usurped the reserved seats of the person suffering from disability, the action of the state government did not call for interest. Repetition. Para 7. In Bhuarao Dugdu Parukar, it was observed no judgment of a court, no order of a minister can be allowed to stand if it has been obtained by fraud. That was on a fraud matter. Now, if Lordship has para 9 at the 5th page, page 795 serially of the book. Page.
That's also on fraud.
Para 9.
That's also on fraud.
That's also on fraud. We come to that part. Now, para 10. The division bench of the High Court has ignored and overlooked the material fact that verification has already been done by the medical board, and it has been found that the certificates of 21% were fraudulently obtained. The High Court has issued a direction in the impugned order for physical verification of the candidate by the authorities, and in case he doesn't suffer from the disability so certified, candidate can be subjected to fresh medical tests. The High Court has overlooked that on mere physical verification, it may not be possible to know various kinds of disabilities such as eyes, ear impairment. This can only be done by medical examination, particularly when the High Court itself has observed that in case there is a genuine suspicion and fraud has been committed, medical certification can be reopened. Direction issued in this regard has not been questioned by the respondents, and in fact, process for verification was already over when the High Court had issued the aforesaid direction. In our considered opinion, in the peculiar facts of the case, such a fraud and genuine suspicion raised in the representation lodged by the Viklang Sangh, and when 21% of such certificates have been found to be fraudulent law, then there is no scope for the division bench to interfere and issue order to perpetuate fraud. Writ is to be declined in such a scenario, and no equity can be claimed by the respondents. In the circumstance, we set aside the impugned judgment and order of the public. Another judgment. Huh? Another judgment, there's a judgment of 2017 by a High Court, my lord. Dinesh Das. Dinesh Das judgment. Perhaps this was not handed over, my lord. I'm handing over a copy now. Copy exactly 9. CCM next. 2017 SCC online Guwahati 313. WPC number or WPC number, WPC number 2162 of 2017. Give it in WPC 2162 of waiting. Wait for them to take copy. I could not give them a copy.
They normally avoid giving. They normally avoid giving.
On the last occasion, when I was requested, I gave the entire list. This is what we found yesterday evening. I am not given. I'm waiting for them to get a copy. Even the what have we done?
They are placing in certificate that it shall not given once.
No, that a notification, my lord, it's a public document. I don't. The public document, they did not bring it to the notice of term. I go to that, I will not. We'll just go by the law, my lord. What can be done, what cannot. Para 2, my lord, I'm reading. Heard on admission. On response to employment notice dated so-and-so published by the Northeast Frontier Railway, the petitioner applied for the post of stenographer under visually handicapped category. In the advertisement, it was mentioned that out of 30 posts reserved for physically handicapped candidates, 8 posts were reserved for visually handicapped candidates. The advertisement also mentioned that those candidates who suffer from total absence of sight, visual acuity not exceeding 6/60 or 20/200 in the better eye with correcting lenses and limitation of field of vision subtending an angle of 20 degrees shall be considered as visually handicapped person. These kind of description that they give, perhaps the reason why it should be left to the experts and we should. The petitioner participated in the written test held on 36/2001. He, being from the state of West Bengal, produced a handicap certificate dated 18/7/2000 issued from the office of the superintendent. This certificate reveals that the petitioner is suffering from 30% disability. Even then, he was allowed to participate in the stenography test held on 14/9/2001 to 16/9/2001, whereafter he was declared selected. But while approving the panel, his name was withheld for verification by Medical Board of Northeast Frontier Railway under instructions of the competent authority. The petitioner then appeared before the medical board, which after examining him opined that as per the standard mentioned in the for the visually handicapped, he cannot be classified as visually handicapped because his percentage of permanent disability is 30%. Therefore, thereafter the petitioner was also informed while communication dated so that he cannot be classified as visually handicapped. He was thus finally denied appointment on the post of stenographer. Aggrieved petitioner filed OA before the Central Administrative Tribunal, which has been dismissed. The sole question for consideration before us is whether the petitioner has been wrongly denied appointment on the ground that he cannot be classified as visually handicapped. The section 33 of the Person with Disabilities Equal Opportunities Protection of Rights and Full Participation Act 1995 deals with reservation of posts it reserves under, that is how the posts are to be reserved. Para 7. From the reading of the above quoted section 33, it is clear that 3% of vacancies in every establishment has to be reserved by the government for persons who are suffering from disability, which 1% for further reserved for persons suffering from blindness or low vision. Expression blindness and person with disability are defined in the section 2B and 2T. According to 2T, person with disability means a person suffering from not less than 40% of any disability as certified by the medical authority, what we now call the benchmark disability. And according to the section 2B, blindness refers to a condition where a person suffers from any one of the following conditions, namely so and so. 8. The handicap certificate dated 18/7/2000 issued by the government of West Bengal through the office of the superintendent SD hospital establishes that the petitioner is suffering from 30% disability, much less than the prescribed 40% of disability. This certificate has been filed by the petitioner himself. But yet the Northeast Frontier Railway in all fairness arranged for his another medical examination by its own medical board. The petitioner also without any protest appeared before the medical board on 11/4/2002. Medical board after examining him opined that as per the standard mentioned for the visually handicapped, he cannot be classified as visually handicapped person because his percentage of permanent disability is 30%. The petitioner is therefore not being found to be a person with disability within the meaning of so and so, and as such, he has rightly been denied appointment. It is true that much after a decision of denying appointment, the petitioner had filed another subsequent medical certificate dated 2/9/2003 issued from the same hospital of West Bengal, wherein it is stated that he is suffering from 100% disability. We have serious doubt about the genuineness of this certificate. We say so because it is contradictory to the earlier handicap certificate dated 18/7/2000, issued by almost the same team of doctors. Apparently, the petitioner has somehow managed to obtain the certificate to procure appointment on a post reserved for visually handicapped person. But as seen above in the earlier handicap certificate, he was shown to be suffering from 30%. We are also not impressed with the submission of the petitioner that after his selection in the test, he cannot be denied appointment. Petition admittedly applied for the post of stenographer in the category of visually handicapped person, which he is really not. What all these judgments, my lord, seem to show is that once there is a certain certification saying that a person belongs to certain something, I'm a matriculate, someone is a graduate, someone. Now that certificate is always verified with the concerned authorities whether I have it or not. Here we have a case where it is a medical condition, a physical condition. Certificates here and there, what is the actual physical condition has to be assessed by someone. That assessment was proposed. That proposal was accepted, presented before the medical board. The person presents himself, gets a certificate to his detriment, then comes back and check.
What happened in the other case with when they went on appeal?
In appeal, my lord, what I found in the writ appeal order, I was searching by name. If it is the same case, it was withdrawn with liberty to file a review.
Okay.
Review, my lord, we have not been able to trace in the High Court system because it related to some other department, not the education department. So we do not have a copy and I could not trace it out here because we do not have the diary number, filing number or anything. But otherwise, the DB is not in session of the matter as of now. There was no stay in the matter. Till there's a stay on the review or something like that happens, the order of the learned single just prevails on the case. That is where the trouble is. One suggestion, perhaps, may not prejudice them, may not prejudice us. If they show that our board did not even consist of experts, that is what has happened in other paramilitary forces cases or other cases also, that if they can show that there is no expert available or the required conducted tests were not there to save time, specialists, they can appear before specialists to find out what is the procedure. That is one aspect of the matter, but that will again be subjected them to medical assessment. But it cannot be said in law that they will not be assessed at all.
Another aspect of the argument from the learned senior counsel was that this batch of writ petitioners, they were rejected after the medical re-verification. But some few other candidates, some few writ petitioners, I think about 21 or something, 29. On the basis of the earlier disability certificate, they have been again given appointment.
Perhaps not only on the basis of the earlier disability certificate. That instruction I do not have on writing. If it is solely on the basis of the earlier certificate, I'll have to get a instruction as to why those were entertained when there was another certificate saying that they did not have the particular.
That part you'll have to clear up. Because that is a strong point.
Yes, 21%.
On one side, they've been rejected. On the other side, they've been accepted.
Perhaps my lordship takes it up. I will also try to find out, or they produce those appointment letters that they have appointed a judge based on that certificate.
They've given a list of the.
The list is not.
We have filed an affidavit.
We are not being able to trace it.
We have filed an affidavit saying that they have already participated in medical boards. Thereafter, they were selected finally in another recruitment process by the respondents.
Now, we do not know whether those certificates have come back and whether it was on the basis of the certificates only on the post of physically handicapped, or have they been on merit, they have come out without taking the help of that particular disability or not. That all aspect has to be gone into. What I would restrict myself today is to say that whatever test that was under challenge in this writ petition, in these writ petitions, my lord, at that particular point of time, they having participated, we have the right to find out whether they are actually that percentage of disability. That would not be.
No, your argument so far so good.
There are 29 persons, my lord.
But this 29 persons.
Yes.
Who have been rejected by this medical re-verification board, they've been given appointment on the basis of their original disability certificate. This is one point this you have to clear.
Since
You'll have to clear.
We have already, additional affidavit is filed, courts.
We have one green copy. My clerks don't give it.
What you Begum, you filed additional affidavit. 1 minute, I have it. That was on 15th of March.
Lordship, the affidavit is with them. I don't have the.
No, it may have been served upon us, my lord. I'm not denying that. Things the bunch that comes to the court from email that doesn't continue.
10th of March 2020.
Lordship should see that the 2357, if I'm just having a look at it, my lord, page number 2357 is the list given by them. Starts at page
No,
2346.
there's some paging mistakes. I mean, it is not telling with you.
We have corrected.
Oh, you've corrected.
Yes.
Okay.
It is 2346, my lord. It starts at 2346, that affidavit that I have been given.
2346.
Yes, my lord. And
1 minute.
it is correct. 2346.
That's an affidavit in reply.
Yes, it is stated as an affidavit in reply. There, lordship would find it page 2357, the list of the persons. It starts there. Marked out in red, if I'm not wrong, they are highlighted. Serial number 1 is Zahid Hassan Ullah, lordship find.
Yes.
Lordship, category applied for unreserved. But at the top, it is a this one. Finally, so post of privilege last but a person beside this PW under 3 years. Unreserved PW, PWD he unreserved to Kapo, no? What I said, it's almost 1 o'clock. Lordship will give me till 2 o'clock.
Oh,
At 2 o'clock, my lord.
we have
During
to-
lunch, I'll find out this.
We'll continue it.
It was really right.
We'll resume at 2 o'clock.
This is the medical board is what all of them are at 2 o'clock.
It will be helpful, Begum, if we can get the appointment orders also.
Lordship, they.
Citizen,
Yes.
of these persons.
Of these
Or 20.
persons who are appointed.
Okay.
And then that would facilitate
Yes.
Majumdar to verify whether this, what you have stated is correct. Not only not the question of issue, whether you have stated is correct, no, but then on what basis they were given the appointment.
And if, my lord, even if they've been found fit by the third medical board which they underwent, I'm calling it a third medical board. First was rejection, then the second again got rejection. They applied again, this was the third. If they are found fit by the third medical board, then this opinion of the second medical board and the third medical board would be something for the experts to answer. As on the date when we
No,
rejected
that's why. See, so far your argument, so far the re-verification part is concerned, all these things, that is good. This court is
I have answered
fine.
to this so far,
No,
this
no.
particular case is concerned.
No, don't worry.
Yes.
I'm not finishing off the case. But now one thing is,
Cannot be applied as a
one
straight
thing
check.
is distracting this court, particularly this 29 persons who were rejected by this medical board, re-verification. How have they been given appointment?
because they underwent a third board.
No, that's why. How could a third board could have come to the conclusion
They are-
that they have the benchmark disability?
Could it be,
So it-
my lord? I can ask for the records. I can ask for the records of both the proceedings. These 29 persons medical.
No,
board
if,
proceedings which have come.
can you help him out or?
These
No, the-
details are already there. in
The
the
details are
affidavit.
there. I'm not saying. about
They
that.
can officially collect even
Then-
the appointment letters of these individuals also.
No,
Those
that
will
might-
be lying in
I'll
one
do that.
bunch.
What I propose is, these 29 persons, what was the medical board's view in the during the selection process where they have been appointed? what was the medical fee is what I'll place before this court. That record.
Have you given him a type copy of this?
Lo-
Which one you, this one, which you have submitted now?
Lordship, we have not given to them. I'll
Give him,
I'll
and then
give-
that will help you.
এই G29 জনক appointment দিছে।
এইখিনি মই তেওঁলোকৰ মেডিকেলৰ এতিয়া যিখন মেডিকেল বৰ্ড হৈছিলে মই তাৰ চাৰ্টিফিকেট
এইখন নহয়, এইখন।
But that's all right, but then my lord, whole thing is fishy. It shows prima facie that there is no consistency, and because there was no formally formed appellate medical board for the entire state. Today's few doctors have been asked, you consider. Tomorrow another few doctors will be asked, you consider. That is not the way. Law doesn't prescribe that. They will have to maintain a certain standard that will be applicable to the entire state as a whole, so that they will apply those standards and consider all the candidates in that one standard. This is not there now. So I'll come and answer.
That is what is.
I don't think they have.
That point has to be answered by the medical board, who's respondent number 5 here, whom I do not respond, whom I do not represent as of.
No, fine.
Principal of the GMCS has to say why his own board is giving different.
Can you?
Yes, this I will find out. I'll get the medical consult.
How long will you take?
Today,
Huh? Tuesday or no? 28th, my lord. November.
That's fine.
20th, my lord.
I heard Mr. K.K. the learners, their counsel assisted by MS and learned counsel for the petition.
29.
2829, whatever.
29.
Request made by Mr. R. Majumdar, learned standing counsel, secondary.
Department of School Education.
Okay, learned standing counsel, Department of School Education. List the matter for further hearing. When do you want?
28th, I was suggesting, she suggests 29th.
That is hearing date 28.
28th is a hearing date. Medical board to represent patients. Constitution to preside a principal of an activity.
Medical board is represented. Party is
Number
there.
5, my lord. Respondent number 5.
Who is representing? I think it was last.
Health department will be the health
Go,
department.
go.
I will inform. তোমালোকক বেলেগ বেলেগ রিপোর্ট দিলে সেটো দিব নাই কাম একেকিটা মানুহ এখন বোৰ্ডে ৰিজেক্ট কৰি দিলে চাকৰি নাপালে
You have for the health.
Yes, I'll get that.
So on 28th, for further hearing.
Yeah, for further.
This further, yes.
Right. No, প্ৰথম এটা 2021 ৰ
For the time, can this matter with the timing?
Why?
Petitioner is not there.
You are adjourning on behalf of the petitioner.
No, Lordship, my senior is also coming.
None appears for the petitioner. Mr. K. Gogoi appears for the Higher Education Department. And Mr.
A day on behalf of.
A. Day Leonard Soinso appears on behalf of Mr. P.G. Fukan. Leonard Standing Council. KKH. What do you call this? Handic. Please, doctor, 2 weeks.
5 and 6.
Item 5, past orders. After 2 weeks.
Item 4, Lord.
I've already passed orders. You're not there.
I just come from the toilet. I'm ready in this case, Lord.
You're ready.
Can this matter be adjourned for the time being? Lordship? My senior
I'm not
is-
adjourning for the time being. If your senior is not there, we'll fix a date.
He's there only, he's coming.
It's not there. Okay, cancel the order. Heard, Mr.
R. Fukun.
R. Foucault. Then the counsel for the petitioner as well as Mr. K. Google and the standing counsel higher education. On request made on behalf of PG Foucault and the standing counsel. So, huh? When? After 2 weeks?
10,
what?
12, not
Huh?
10, 12. 12 will be better.
10th of
10th of
12th.
12, 10th of December. Published.
5 and 6.
If I may, Lordship. Lordship, as per the instruction that I've received, we would like a little bit of time, Lordship, and your leave to file a miscase, Lordship, to withdraw the previously filed petition on, affidavit that was filed on behalf of the UGC, Lordship, and file another affidavit in its place. If your Lordship would be
You want
kind.
to withdraw?
Yes, Lordship.
They will file a miscase to withdraw earlier affidavit,
And file a fresh one, Lordship.
My lord, in that case, if we going through the order sheets, my lord, since 3 years they playing like this, and issue is already settled, my lord, by other high court, my lord.
Yes, see, in the last occasion, you said you wanted to file a clarificatory affidavit.
Yes,
Now,
Lord.
if you have to file it, you file it on time. Otherwise, I'm not giving you so much time. I'll give you a week's time.
Lordship, as little more time, Lordship, if possible, because as per the instruction I've received from my senior Lordship, he has expressed in accordance to the instruction that we've received, Lordship.
My
We
lord,
would like to file a miscase, Lordship, to withdraw the previously thing.
My lord, each and every occasion, separate counsels are appearing. Last occasion, appear someone, one learned lady friend, and before that, another one. Each and every day, senior is not come.
Okay,
And such kind of prayer.
I'll
And
record that. I'll record that. Heard Mr. K.U. Ahmed, and counsel for the petition. Mr.
R. Bhuya, Lordship.
R. Buyal and counsel appearing on behalf of Mr. H. Homa, and standing counsel UGC. Submits that they may be allowed a week's time
Little bit more, Lordship, if
to file the
we can.
miscellaneous application.
Yes, Lordship, and the other affidavit that is to be submitted along
That's
with
why first you have to file the miscase.
Oh, all right, Lordship.
Just a week's time to enable him to file an appropriate application for withdrawing of the affidavit filed by the UGC. Stop. The prayer is allowed. List down. Today is
21st.
20.
it is, my lord,
Okay.
10th of December, my lord.
You want to extend it so long? I'm giving them 1 week. You're saying
Yes,
no
my lord,
adjournment, and then you want
26,
to
26, my lord.
we'll have it on 25th December.
25th, my lord. No, my lord, in November, my lord.
Lordship, any day other than the 26th, please.
Okay. 28th? 28th? 28th of November? Is that okay?
Yes, Lord.
My lord, it may be also as a last chance, my lord, so many dates are already
That will
taken.
7, 8.
Respondent number, my lord, he filed affidavit, my lord. But
You're filing reply or no?
no, my lord, because my lord, no denial by no such, my lord, specified, my lord.
Petition, they have not challenged the debt eligibility advertisement, my lord. And my lord, they have not challenged the clause 6 of the provincialization order, my lord.
Which clause 6? With the order of provincialization?
My lord, order of provincialization, my lord.
Page 81.
Sir, kindly see the prayer, my lord. Page 21 of the writ petition, my lord. They are claiming only the fixed fee per month at 12,150 rupees and
1 minute, 1 minute.
page 21.
should not be so directing the respondent to treat the petitioner at teachers of the.
And my lord, another prayer, a read in the nature of management should not be so directing the respondents to treat the petitioners as a head teacher of their respective school, pay the salary as per their entitlement by relaxing the professional qualification of passing teacher eligibility test. My lord, and about the age, my lord, they have to challenge the teacher eligibility test the notification, my lord.
Which notification now? About the what?
About the criteria of the teacher eligibility test, my lord.
About TET?
Yes, ma'am. And my
Where's
lord,
the?
my lord, our as per our affidavit, my lord.
No, no.
We see the clause 6, my lord.
Where's the notification?
I
Where
don't
the-
have the notification, my lord.
where
They should
the-
have.
where
They
the
should
TET
have challenge
Where the TET qualification is a requirement, you have given that by way of a notification one.
for the relaxation of their age, my lord. They should have challenged the teacher eligibility test the notification, my lord, or
Oh,
advertisement.
So where's that notification?
I don't have. I don't have the notification now. ma'am.
My lord, my case is different, my lord.
Oh.
We are, my lord, a teacher of the concerned ME school, my lord. Thereafter, my lord, by way of my lord, 17 Act, my lord, we are post was were provincialized as tutor, my lord.
Hmm.
But my lord, the
Because
enrollment.
that means you don't have the qualification.
Yes.
I have qualification, my lord. I have DLED, my lord. I have also graduate, my lord. But they provincialize as tutor.
Hmm.
There is a provision in the 17 Act, my lord, regarding honorarium of that head tutor, my lord.
Hmm.
We are the head tutor, my lord. Yes, because my lord, ME school, my lord, more than 100 students, my lord. 4 teachers provincialized, my lord. That means, as per RTE Act, my lord, one senior most is the head teacher, my lord. As per RTE Act, my lord, 2009, my lord. And accordingly, my lord, as per 17 Act, my lord, the remuneration are fixed, my lord, 11,000, 12,000, 1,200, 150.
2017 Act.
17 Act, my lord.
Which section?
My lord, last, my lord, schedule, my lord.
In the schedule?
Schedule, my lord. It's 99 Act. One 127.
Hmm.
My lord, upper primary school, ME school.
Yes.
There is a headmaster, my lord.
Hmm.
And remuneration fixed salary, my lord, 1200, 12,150. And after in third to fifth year, my lord, that 1300.
13,500.
My lord. But my lord, in this case, my lord, the respondent only, my lord, getting, my lord, provincialized as tutor, my lord, and fixing kindly see, my lord, annexus
Let's see a
76.
provincialization order.
76, my lord.
Page?
Page 76, my lord, start. Annexus B series, individual provincialization order, my lord.
Hmm.
Money Kali, name of the
1 minute,
appointee.
1 minute.
The tutor will receive fixed salary at the rate of 10,800. And my lord, as per RT Act, my lord, 2009, my lord, there is no provision for headmaster of the ME school. But my lord, if the enrollment is more than 100, my lord, additional post was, my lord, granted, my lord. And thereafter, my lord, stating, my lord, a full-time headmaster.
This 2017 Act, under this, normally they are provincialized as teachers.
Tutors.
But when they don't have the qualification, they are provincialized as tutors.
Tutor.
And they are supposed to get the qualification within a certain period of time, correct? So where's that provision?
My lord.
Okay.
6. Sixth one of the Act. Educational and professional qualification of teachers. Yes, 115, my lord.
So it's 7, section 7. Correct.
Yes, ma'am.
So what is your case?
My lord. First, my lord, I have to, my lord, receive, my lord, at present, my lord, as the head
No, the issue
tutor.
is this: you are provincialized as a tutor. You
Instead of-
accepted that order.
Yes, ma'am.
Correct.
My lord.
You accepted that order. So now you are a tutor. Now, as per that provincialization order, you as a tutor, you are supposed to get 10,000 something rupees. And for science teacher, I think the science tutor is little bit extra.
Extra, my lord. 12,800.
So you have accepted that provincialization order.
But I am continuing, my lord.
Of course, you're continuing because of that provincialization.
My lord.
And then you have accepted that order. Because why you were provincialized as a tutor is that because you did not have the qualification for to be provincialized as a teacher. Correct. Have you acquired the required qualification within that 5 years? When were you provincialized? In the year 2021.
21, my lord.
So you are supposed to acquire your qualification by 2026.
Only, my lord, TET, my lord. Teacher eligibility test, I have to, my lord, to qualify, my lord.
Do you have the TET qualification?
I don't have, my lord.
Then?
But, my lord, my contention is that, my lord, we are the head teacher of the ME school, my lord, as a head teacher, my lord. As per 17 Act, my lord, 4 teachers provincialized. That means, my lord, more than 100 more than students available in the school. That sense, my lord, head teacher, I have received remuneration of 12,800, my lord. Because I am a head teacher, my lord, 4 teachers provincialized, my lord. And there is a provision of RTE Act regarding, my lord, head teacher.
I'm not getting you. Not getting. You were in the Venger school. When you were there, you were the head teachers.
My lord.
Correct. Now, under the 2017 Act, your cases were considered for
As a tutor, my lord.
for provincialization, and you were provincialized as a tutor,
And
not as a head teacher.
My lord.
Correct.
Correct, my lord.
So you are governed by the terms contained in that provincialization order.
My lord.
Because you did not have the qualification of TET. So now you are supposed to acquire TET within 5 years from the day of your provincialization in terms of rule section 7 of the Act.
Well, till that, my lord, no TET, my lord, has been, my lord, organized, arranged by the respondent, my lord.
Yes, Fukan, what is there in your affidavit?
Provincialized 2021, my lord.
Yeah, holding that every year, my lord. Huh? Oh. After 2020, it is mandatory.
My lord.
1 minute.
Provincial. Yeah. That's something.
Yes, what you're saying is correct.
My lord. And
what they have stated is with regard to the factual position in the affidavit.
My lord. It is, my lord, available record, my lord, as per act. It is prescribed.
So that means you are not entitled.
Yes, ma'am.
But my lord, recent, my
It is
lord,
conducting by the department.
I had, my lord, recently, my lord, the division bench, my lord, categorically stated, my lord, equal pay for, teachers, my lord.
That is a different thing.
My lord, my lord, relaxed that only because of, my lord,
No.
salary, my lord.
Who is authorized to relax the debt? Who can relax the debt requirement?
Government, my lord.
Under which provision?
But
under which provision of the act?
There is nothing in the provision of the act,
When
my lord.
the provision does not provide for relaxation, can they give you the relaxation?
And my lord, division bench, my lord, category stated,
Which
my lord,
case?
equal. My lord, WBCN 2729, my lord.
Party name?
Party name, my lord, Mohor Ali Sheikh, my lord. And series, my lord, who has challenged the, my lord, 17 act, my lord. In this case, my lord, paragraph 179, category stated, my lord, observation regarding, my lord, equal pay, my lord.
Equal.
Yes, 179. Take mark, my lord.
This is not a division bench judgment.
Division bench judgment.
This is a division bench judgment.
Division bench judgment. Necessary is to provide for a regular pay scale to the tutors, which can even be commensurate.
When was this order passed?
My lord, this order passed
When was this order passed?
Malad, I have not annexed the complete copy of that Malad post item.
You get a copy because there's some, I don't know if you have sent that para 179. Direction was issued.
What can clear the air to some extent. What happens is this. His case is that he was taken on as a tutor. He should be made a head tutor by relaxing certain conditions, that is the TET. Now, TET is a thing which has been given by the NCT. The Right to Education Act gave the power to the Ministry of Human Resource Development. They have given the power to the NCT. NCT has made it mandatory.
Correct.
So that part of his petition goes, we cannot have anything to do with relaxation, at least in elementary schools. What is at page para 179 is the Honorable Court held that keeping them at a fixed pay may be a violation of the right of equality, because all are government servants. If everybody does a scale of pay, one should not be kept at a fixed pay. Therefore, we have been directed to consider giving them a pay. Lordship will find if required at the lowest scale. Even that liberty is with us. What this Honorable Court wanted to say that fixed is wrong. Go for a scale commensurating with this particular pay itself. Drop a pay scale where you will be paying this only, but let it be in a scale. That is where we have also prepared a review, because we cannot do that. Tutors are not qualified persons. They are there on mercy. They were not supposed to be provincialized. We did not want them out of jobs. We have kept them up on it, and we have given them the options of becoming a teacher if they can qualify the same, which is not a prayer in the writ petition. So that judgment doesn't come in anywhere in this particular writ petition.
You file a review here?
Yes, madam. We prepared a review, filed it. There are some objections. We need to file in some more documents.
Okay.
So that is not, but otherwise the state is in a balance. So this judgment is not related to the prayers made in this lordship. Will have a look at the writ petition, prayers in the writ petition.
That I've seen.
Ultimately, Malad.
Nothing to do.
Malad, ultimately scale Malad.
You want relaxation of TET?
That means Malad, getting Malad scale of pay Malad.
No,
I don't.
that is not the prayer.
I don't think.
Teacher Malad.
Guide the respondents to treat the petitioner as head teacher.
Teacher.
But Kiri, I think you have a proper study of your case and come back. Today I'm not dismissing it.
After a week, Malad.
On request made by K.R. Patkari, let the constitutional petition. It's the one.
10.
Obliged.
May I please, Lordship? Hello, this matter pertaining to appointment as assistant professor in Disciplinary University. My lord, one advertisement was published by the Disciplinary University
Where the advertisement?
by inviting application for different posts, including post of assistant professor in applied geology. That is page by Lordship 55.
Page?
Page 55. And here, Lordship,
That one.
under clause C, serial number 2, applied geology, and it is prescribed the specialization paper as metamorphic petrology, Lordship, geochronology, and isotope geochemistry. This is the prescribed specialization. And
You are concerned with assistant professor?
Lordship, assistant professor in applied geology.
Was applied
Below, my lord.
Okay, okay.
And specialization prescribed your lordship, metamorphic petrology, geochronology, and isotope geochemistry. And my lord, so far my qualification is concerned, it is not disputed, my lord. And only 2 candidates was participated, the petitioner before lordship and respondent number 6 for the post of applied geology.
Okay, 1 minute. There's a private respondent here.
Yes, lordship. Private respondent.
You agree?
Private respondent number 6.
Okay.
And there is an order passed by one court that subject to outcome of this petition, the appointment of respondent number 6 shall be subject to outcome of this petition. That is order, my lord, page order dated 7/11/2022. appointment of the respondent number 6 in the Dibrugarh University as assistant professor in the Department of Applied Geology pursuant to the advertisement of letter so and so 5/1/2022 shall be subject to outcome of this writ petition. Now, my lord, they file affidavit and I also filed counter affidavit, and they have taken stand that the respondent number 6 got registration for doing her PhD work. That is their contention, but that PhD, that topic is quite different, not covered so far the prescribed specialization is concerned. And Lordship, I am coming to my lord, my case, my lord. So far, my PhD coursework is concerned, that is page, your Lordship, 22 in my writ petition.
1 minute. Which?
Page 22. Page 22, my lord. It was issued on 26/4/2026, 2016. And here very specifically mentioned, my lord, that this is to certify that Dimple Dole, bearing enrollment number so and so in the year 2015, is a bona fide PhD student enrolled in the Department of Geological Science under the Faculty of Science, Guwahati University for the session 2015. And she has successfully completed PhD coursework in 2015 as partial fulfillment of Doctor of Philosophy. Prior to submit thesis, the Guwahati University is mandatory. They have to fulfill partial course, my lord. Now, my lord, in this course, optional paper shown below, my lord, 3.4, here, my lord, geochemistry shown. And 3.8, my lord, number, metamorphic petrology also shown, which is covered in the specialization paper as per advertisement dated, that is, Lordship, page 55, dated 5/1/2022. So, therefore, my lord, so far the affidavit, my lord, filed by the respondent number 1 to 5, the university, that is, Lordship, page.
No, you first complete your facts.
Lordship. And now, my lord, so far this certificate regarding
no, what you're trying to say is, in terms of the advertisement, you have the qualification.
I have qualification.
Correct.
And there is no dispute regarding the affidavit filed
So,
by others.
after that, what happened?
Lordship, now, my lord, I have participated in the interview, and now, my lord, this respondent number 6 has been appointed. That is, my lord, I have a cell here, my lord, page 58. She has been appointed as assistant professor in applied geology, whereas she does not have such a specialization paper.
Okay.
This is the case, my lord.
You're saying that the private respondent does not have the
Specialization paper.
Okay.
As per prescribed advertisement.
In terms of the advertisement.
Now, my lord, their contention, university file affidavit in opposition, respondent 1 to 5, page, my lord, 63. And they, university trying to establish by taking another Lordship view that PhD registration, paragraph, my lord, page 65, paragraph 9, it has stated that the registration topic, page, my lord, 65, I am reading, my lord, that with regard to the contents of paragraph 8 of the writ petition, the deponent state that the respondent number 6, Tina Soike, has specialization in isotope geochemistry as reflected by her PhD registration topic, in quotation, studied on stable carbon isotope and palinostratigraphy of burial groups in parts of whole trust belt of Nagaland, India. So it is ultimately, my lord, they try to implicate a new qualification. This topics has not been followed so far advancement is concerned. And this registration 16/3/2017, actually it is appeared annexure 1, page, my lord, 69. Page 69, your lordship. This registration for PhD, that cannot be taken into account as specialization. Page 69, my lord, dated 27/3/2017 is a notification, and respondent number 6 name appear under serial number 2, MS Tina Shoikia, and topics shown is studies on stable carbon isotope and palinostratigraphy of burial groove in parts of whole trust belt in Nagaland, India. And that cannot be a specialization paper. And very important point is that, and she has yet not completed her PhD. Just in the year 2017, she got registration. And registration topics cannot be treated as a specialization. This is taking into account. And this plea has also taken by the respondent number 6, similar stand taken. Now, my lord, here, my lord, I have also made reply. So far, this affidavit in opposition filed by respondent 1 to 5 is concerned. My reply, my lord, saying that my reply, my lord, page 81 and paragraph 3, my lord, in my reply. That with regards to the statement made in paragraph 4 of the affidavit in opposition, submit that for obtaining public employment in pursuance to a advertisement without having a specialization for appointment on the post of assistant professor, vitiate the process of appointment of respondent number 6. Annexure 1, page 69 has revealed regarding a notification dated 27/3/2017 in respect to a registration for a degree of PhD work, which cannot be taken into account for specialization as contemplated by the advertisement in question. Further, the respondent has failed to say whether the respondent number 6 has completed her PhD work at the time of interview, and by taking into account of specialization from such incomplete coursework, for such selection, no one can take any undue advantage in accordance with Chattel law. Now, so far, your lordship, the paragraph 9 is concerned. I have stated, my lord, page 85. Very interesting case, your lordship, that with regards to the statement made in paragraph 11 and 12 of the affidavit in opposition, the deponent submit that entire interview was biased as because the supervisor of respondent number 6, in respect of her research work, namely Dr. D. Bhuya, head of the Department of Applied Geology, Divrugarh University, was taking part in the interview selection process and has given the high marks to the respondent number 6 in the interview. Surprisingly, that the deponent obtained her PhD, MSc and PhD qualification from Guwahati University, and respondent number 6 obtained her MSc qualification from Divrugarh University. And being internal student of Divrugarh University, respondent number 6 has selected arbitrarily and in unfair manner, and deponent has been neglected by the selection board, despite the respondent number 6 does not possess specialization paper as per advertisement. Thereby, the impugned appointment letter cannot be survived and is liable to be set aside, and deponent is to be appointed in accordance with law. Now, my lord, so far, affidavit filed by respondent number 6, that is page lordship 89. And she also taken similar stand regarding the PhD registration topic. Here, my lord, paragraph 9, page 92. Affidavit filed by respondent number 6. Lordship.
Yes.
That in paragraph 9, I am coming, Lordship. With regard to the contents of paragraph 8, the deponent begs to state that the respondent number 6, Tina Soikia, has specialization in isotope geochemistry, which is reflected in her PhD thesis, pursuing by the respondent number 6, where the topic for the PhD registration is studies on stable carbon isotope and polinostratigraphy of boreal group in parts of fault thrust belt of Nagaland, India, dated 16/3/2017. And under Divigor University, the deponent further begs to show. And paragraph 12 stated. Paragraph 12, she stated, my lord, in the middle portion, that I am coming from 12, my lord, that with regard to the contents of the paragraph 11, the deponent begs to state that the Tina Soikia and the petitioner had participated in the interview held on for the post of assistant professor in the Department of Applied Geology. In the interview, Tina Soikia had outstanding performance in comparison to the petitioner. The respondent number 6 further begs to state that on the basis of the performance done in the interview, Tina Soikia has been appointed, and the appointment.
Let us go back to the advertisement.
Advertisement. Advertisement, my lord, page 55.
Majumdar, these qualifications, one says education, specialization, MA in English with MAd. What is this? Then applied geology, then Assamese one specialization.
Yes. No, we have advertised different posts.
Oh no, that's why.
Assistant professor, the one post that is available is in the post of education. It is an assistant professor education. For that education post, we need a the field of specialization has to be, the candidate has to be.
Okay,
MA.
these are all different
Yes,
posts.
yes.
Even applied geology.
Yes, applied geology is one topic. One will appoint an associate professor.
Okay.
Assistant professor, I'm sorry, madam.
Assistant professor. And specialization means what?
We require a specialization. What should she be knowing?
That's why.
Teach.
Is it required to be an MA? Is it required to be a PhD?
Madam, this is this assistant professor in these subjects. They are laid down by the UGC norms.
Correct.
Anyone who fulfills the UGC norms can apply.
Oh.
So with a net at that point of time, if one has a net, one need not be a PhD, and she has to have a specialization paper on this particular topic. That was all that was necessary.
At this point of time.
Yes, because it has to fulfill the net, telling which manner we cannot give. Manner. It's a university post.
Oh.
But for when we say of education, now education would have different subtopics on it. So therefore, we say that we need a person who's an MA, at least
in English,
with MA.
With MA.
She should be an MA in English. It should not be history or some other topic. Although the education is
correct.
So specialization is the main thing issue. Yeah. And I also, my lord, completed net qualified, and PhD also completed.
About the response 6?
Response 6 also net qualified, but net qualified doesn't say the specialization paper. It is quite different competitive exam. Here there is no any specialization paper. It is a competitive examination, like conducted by UGC. And my lord, so far, my lord, so far, this advancement is concerned. Here emphasize on the specialization, like your lordship already point out, subject English, whereas specialization education where specialization emanating is. So the specialization is emphasized in this advertisement. So specialization in the prescribed qualification, that should be followed mandatorily. And I have such specialization, but the respondent has no such qualification, but they try to implicate new norms when advertisement is on process. This is the case, my lord. When advertisement is going on, selection process is going on and participated, they cannot add new qualification. That is, they try to implicate the topics, registration topic. That is quite different. That is not identical so far this advertisement is concerned. This is the case, Your Lordship. And Lordship, in this case, my respect, I would like to read upon some judgment passed by one of Supreme Court in state of Gujarat, my lord. State of Gujarat and others versus Aravind Kumar, T. Tiwari and another, my lord. I relied upon para 14. Citation, my lord, 2012, 9 SCC, 545. Paragraph 14 says, a person who does not possess the requisite qualification cannot even apply for the recruitment for the reason that his appointment would be contrary to the statutory rules and would therefore be void in law. Lacking eligibility for the post cannot be cured at any stage, and appointing such a person would amount to serious illegality and not mere irregularity. And now it is covered case because they try to implicate new norms. So far the specialization concerned, when she got registration, that topic is not covered so far as specialization concerned. Now, my lord, another judgment, decision, my lord, Honorable Supreme Court passed, that is my lord Ashok Kumar Shankar case, citation 2007, 4 SCC 54. Here, my lord, paragraph 20, I rely upon. Paragraph 20, lordship. Possession of requisite educational qualification is mandated. Paragraph 20, my lord. Possession of requisite qualification, educational qualification is mandatory. The same should not be uncertain. If an uncertainty is allowed to prevail, the employer would be flooded with applications of ineligible candidates. And here, my lord, so far topics is concerned, it is uncertain. Topics not covered so far as specialization prescribed in the advertisement. But this is the case, lord. And I'm being suffered because, and so far my qualification is concerned, there is no any single whisper, no dispute arises.
It's just that according to them, the respondent number 6 did better. Did better than
They done well in the interview.
fared well.
Yes. That cannot be when.
But then how about her qualification?
Respondent number 6. We've said in the affidavit, our experts or our selection committee says that she meets the standards. That is where the whole difficulty comes in, my lord. When one says that this is not a particular qualification, that is not a particular qualification. Lordship would find that in the earlier cases, 2-3 days ago, my lord, Lordship was dismissed a petition where they wanted to say that we are qualified enough and we said you are not qualified enough. Supreme Court has been consistent. These subjects are better left to experts, which would contain what and what not. The Lordship remembers that history case, my lord, where people were saying that we have got the post.
No, that part I remember.
So,
but then here there's something is that The respondent number 6 has not completed her PhD.
She did not complete on the date of the last date of application. It's a pot calling the kettle black.
Oh, you did not also complete your PhD.
No, PhD, my lord, not required.
Now
But
he
so
comes
far,
to not
no.
required.
I have completed. I have
You should give the
stated.
complete picture.
No, I have stated that at the time before interview, I have completed, and at the time of interview, I have submitted my thesis, and the prescribed form regarding the given the mark has not been furnished. I have filed additional affidavit that should be furnished, and they are only reflected that I have completed my PhD. And so far, my lord, I have also here, my lord, page, my lord, PhD, my lord. Here I have PhD certificate also. Page 43. This is my Doctor of Philosophy provisional certificate. Page, my lord, 43, my lord. Doctor of Philosophy, PhD 2022. Here, my lord, thesis, spectrology and geochemistry. This is also covered the specialization. So far, my qualification, I have pleading is concerned. There is no any contention made by the other side regarding my specialization, regarding my PhD. No any pleading is there.
Yes,
Lordship will see the qualification of PhD. If he says that it is compulsory, then it has to be there on the last date of submission of applications. Advertisement says the last date of submission of application would be 28/1/2022, page 55, first paragraph, 5 lines from the top. Certificate of PhD at page 43, Lordship will find, doesn't have a date.
That's what I was looking. When
Then
did you-
his
when did- when
statements,
did-
then his statements in the writ petition, Lordship will. Para 6, page 8.
1 minute. That was page 35, isn't it?
35. Page 40.
No. That was page.
43 is the certificate.
And para?
And Lordship would find page 8, para 6. He avoids the date.
No, because this certificate does not contain date. How I can put date?
She knows when it is received by him.
And Lordship,
Which was received in the month
my
of
lord,
January,
issue
February,
is
March.
involved.
happened
My PhD coursework. I relied upon PhD coursework, page 22. And I have completed this so far. This specialization.
How about the respondent number 6? You have completed.
Malak,
You've completed your PhD.
have you completed a PhD?
No, I'm pursuing that.
Both
You
were
have-
pursuing their PhDs at that particular point of time.
Now you have completed.
No,
At the but at the time of submitting the application, both are pursuing their PhD.
but my PhD completed.
Was not a mandatory requirement for consideration. Neither of them had PhD as on the last date of application, and therefore both were considered. These were the only two candidates who had participated. Now, the only ground on which the petitioner is trying to say is that I have got a paper, I have submitted a part completion paper saying one of the subjects which Lordship will find, the part completion thing which was referred to, page 22, Lordship will have.
This coursework.
Let us for a moment assume, madam, that his allegation being that she did not have the specialization, she could not be called a specialist on a particular paper because she did not have her PhD. as on the date when this was produced with her advertisement or with her application form, Lordship will find as partial fulfillment of Doctor of Philosophy is at the top. This is partial fulfillment. So the PhD not completed. If we accept the argument made on behalf of the petitioner, then even she did not have the specialization on that particular paper. It was half-baked at that point of time. So therefore, my lord, I say the specialization which has to be considered is prior to when you get into the PhD course. Something which you did prior to when you were in the PhD. All the other essentials have been considered by the selection committee. I have the
No,
record.
he has taken one more ground.
Yes.
That the respondent number 6 supervisor was also in the part of the interview board.
Is the supervisor a party here? Where is the malice and bias? And I'll show from records. He gave the least marks to this particular candidate.
But he was a member of the interview board.
That does not stop my lord. In fact, one repetition, I forget the name. Cotton University, same allegations were made. Repetition was dismissed. Even when the particular person was made a member of party respondent by name. I can give it in 5-10 minutes. My lord. That was of Cotton University matter, where I had appeared for the particular PhD person. Now, when we go through the records, if there is a ground of malice or bias, then even if it is, we have to assume malice in law or something, that man has to be a part. He is not a part. Records would show there was no bias towards him. The bias was against him, against the person concerned who has been selected. Records are here. The photocopies of the records are here. I do not go beyond that. The mark sheets given by each of the person, marks given by each of the person is available here. He doesn't give me the name. I do not know. So, but I was told. BK বলবা না? কার নাম তো কইছিলে আপনি দিগন্ত ভূঁইয়া? D ভূঁইয়া, দিগন্ত ভূঁইয়া. Okay. You are supposed to go. It will go to the court. I will say.
That has not been furnished before this court.
Will not be. Records are produced, not furnished. Okay. Yes, D Bhuya. D Bhuya, Dimple Dole gets 3 points. These are academic record marks. One cannot manipulate that. Research and performance. Dimple Dole gets 4 and 8. These are on the API scores. One cannot manipulate that. Then it is domain of knowledge and skill. Then it is interview. Domain and skill. It is Dimple Dole is 8 and Tina Sakya is. No, this is not Bhuya. Bhuya is another one. This is not Bhuya. That's shown that part. I'll flag it up, madam. This here.
Okay, you flag it up.
I'll flag it up. I'll push that before that. But the first thing, if there is an allegation of that sort, he has to be implemented as a party. That is the first. Second, the moment the interview was over, was the time when they were required to come down and say that this man is there. I'm not satisfied.
Okay, heard Mr. K. Boya.
And I'll bring this on.
Learned counsel for petitioners, learned standing counsel, delivery. This the matter on. When do you want?
Part matter.
12th, maybe 13th, 12th or 13th of December. Madam.
Okay. It's up to you. You want it on a hearing day or the?
On a hearing day is
okay. 12.
Matter may part heart, madam.
No,
already hard completely.
Not hurt you completely. Let's see. It'll come up.
11.
I love this.
My lord, here in this case, WPTBC was supposed to file an affidavit. But my lord, I have a technical problem. The problem is that my lord, the WPTBC department is no more in existence from 2022 July. Now, this falls within the domain of World and Welfare Department. I have informed my friend that he has to implement, unless they are implemented, my lord, that affidavit cannot be filed, my lord. Who will sign the affidavit? So, my lord, yes,
Mr.
M.
Kalita, learned counsel for petitioner. Praise for how much time? 1 week time?
Yes, ma'am.
Praise for a week's time. To file an appropriate application for implement of necessary parties. Praise allowed.
Here, my lord, finance also let my lord allowed to make a party on finance.
No, that's why I'm saying I'm giving you a general order.
Yes, sir.
You can bring in anyone. List after one.
Obliged.
12,
Please, your lordship. Lordship, I am seeking a week's time to file my reply, your lordship.
You want a week's time?
Yes, your lordship.
Mr.
I'll be filing tomorrow.
Mr.
As Gautam, your lordship.
Is Gautam, then a counsel for petitioner, prays for a week's time to file reply affidavit to the counter filed by the respondent number.
Respondent number 3, your lordship.
Filed by the respondent number 3. Praise allowed. List after 1 week.
Oblige, your lordship.
15,
May I please, your lordship? Lordship, my senior is out of station due to some difficulties.
Who's your senior?
Mr. A.K. Talukdar.
On request made on behalf of A.K. Talukdar, learned counsel for the petitioner. List after
1 week.
after a week.
17 and 18 order.
For lordship's earlier direction, I have received instruction, lordship.
So why is it coming for orders? Okay, this is the case.
Lordship.
1 minute. Any private parties are here?
My lord, in item number 17, there are certain principles, my lord. I think their services are not complete yet.
Item 17.
17 and 18 in both, my lord.
17. You don't have the brief.
My lord, I have. Item 17.
17.
Item respondent number 6 to respondent number 21, my lord.
No, notice not gone.
Notice gone, my lord. We have taken steps also.
Okay. Notice was issued.
Yes.
And whether it is
In 18, my lord, thinks notice has not been issued. It
was issued on 30/10/2024. Maybe we have to await service report.
But my lord, the reason why the matter was fixed today, but actually in this matter, my lord, senior counsel Mr. Didas appears. He's on legs in another court. But having said that, my lord, since I think it's the last item, second last item, my lord, it will not be appropriate to adjourn the matter for time being. But my lord, the issue why today was fixed that regarding the principal appointees, item number 17, there were certain issues regarding the principal appointees that they have been released from services. So your lordship, on the last occasion, my learned senior friend, he said that regarding the 450, there was a cabinet decision which undertook that all the 450 temporary guest lecturers, yes, they will be subsequently absorbed in the 3L. And he further stated that it includes both the DT appointees as well as the principal appointees. So, but he further stated that he will bring pinpoint instruction whether the principal appointees will be.
It is only in respect of lordship the
451.
No, 451 in respect of appointment done by the director, not by the principal. In respect of item number 18, lordship, they are all by the directorate, lordship. Their services, lordship, they will be considered under 3F as per the cabinet.
So for item 18.
Item 18.
So for
Item 17, they are the principal appointed. They are not within the considered term. And we'll file affidavit, lordship. I have received instruction if required, lordship. Otherwise, item 18, lordship, they are within the considered term as per the cabinet decision, lordship.
Okay, item 18 we can
Yes,
we can wait. What's 17?
17, lordship,
They are not under consideration.
They are not under considered term. They are the principal appointee. So I'll file affidavit then, lordship. My friend also, Lordship, get an opportunity to reply.
But what about the notice?
Regarding my lord, item number 17.
Huh.
It's
Notice to serve, notice probably not served by.
Notice is not served.
So Lordship may issue formal notice in the meantime.
No, I've already issued
They will
notice.
take steps.
yes,
They
we
will
will take steps.
They will take
But,
steps.
my lord, only one prayer, my lord. The
No,
only
no.
apprehension.
Earlier notice was issued
Yes.
They have to take steps, Lordship.
and they were to take steps on 6 to 10.
Yes.
Now they have taken steps and the notice was issued on 30/10.
Lordship,
So
I wait for service report.
We have to await service report.
Yes, yes. And, in fact, on the last occasion, we had filed one IA to bring on record the subsequent developments. That's IA Civil 3427.
Okay.
My lord, this IA was filed in case of the principal appointees. And this IA was regarding the subsequent development in case of the principal appointees in respect to their release orders. Some of the principal appointees have been issued release orders. In page number 22, if your lordship will see,
Yes.
these are the persons who have been appointed in place of some of the petitioners. Page 22
It was done as
and
per Lordship's
21.
direction. It was done as after completing that.
So the third party right is there.
Lordship.
Yes.
They'll have to be made parties.
Yes. My lord, the only apprehension is that the matter might become infructuous if they are removed from services. That is the only apprehension. Yes, I will leave it to you.
As per the law, Lordship, they are not
But
entitled.
the problem is that you have not participated in the examination also, isn't it?
Yes, ma'am.
Then what can we do?
And everything was done as per my lord's direction. They are all.
Okay, I'll let him file his affidavit.
Yes.
In the meantime, we'll await service report. I'll give you a short time, then we can consider the matter.
Yes.
But Mr. K. Mohammed.
Yes, ma'am.
Then counsel for the petitioner. In both the writ petition.
In both the
Mr. K. Google and Standing Council Higher Education
Lordship.
Department submits that he has received instructions
Lordship.
and prays for 1 week.
Was it 10 days time because our director is in the conference outside India, Lord. So 10 days time, Lord.
And prays for 2 weeks time to
Lordship.
file affidavit. Praise a lot. Stop. In the meantime, await service reports on the respondents. 764. 6 to
10, Lordship.
10 in WBC number 4764 of 2024. Others, though, there's no.
Others, my lord, I think formal parties, my learned senior friend will be appearing for the others. Higher education technical.
No, in the other petition, notice was served, but then
My lord, in respect of which item, my lord? 18 or 17?
4350.
4350 is Lordship.
You entered appearance on behalf of all the respondents.
18. 18, Lordship. Probably there is a.
You entered appearance on behalf of all the
Yeah,
respondents.
I can up to 5 Lordship.
Huh?
Up to 5 Lordship.
Hmm.
Up to 5 Lordship. Up to 5 Lordship.
Then you cancel the order. In WBC 4764 of 2024, right? Heard Mr. K. Mohammed, learned counsel for the petitioner. Mr. K. Goel, learned higher education, standing counsel higher education, submits that he has received instruction and prays for 2 weeks' time to file counter affidavit. Praise a lot. In the meantime, our service report on the respondents 6 to 10. Huh? But there's a big mistake then.
Yes.
Otherwise, they are under a considered zone. Lordship may issue formal notice, they will take steps.
No, 4350.
4050
Oh, sorry, 435 DT appointees.
They are DT appointees.
They are under zone of
considered,
control.
they are no effects. So
No, no, but notice has not gone, no.
Losime issue formal
Formal
notice.
notice.
Formal notice. They will
But Mr. K. Mohammed, Learning Council for the Petitions. Mr. K. Gogoi, Learning Standing Council Higher Education submits that he has inadvertently entered appearance on behalf of all the respondents. However, comma, he can appear only on behalf of the respondent number one, two, five. Stop. Accordingly, comma, the petitioners are directed to take steps for service of notice on the respondents 6 to 21 by registered post AD within 1 week from today. Stop. But then this will have to come up together, isn't it?
Yes, madam.
otherwise Losime segregate it also. Losime after 3 weeks, Losime fix it both the matters. Losime will come up with a affidavit.
Okay. Okay. List after 3 weeks. In the other one also, then they say list after 3 weeks. Mohammed, I'm fixing it after 3 weeks. then.
Yes, madam.
Okay.
Obliged.
19 and 20 hearing.
Lordship, conducting counsel T. Chakraborty is on his legs at court number 13.
Okay.
The matter may pass over for the time being.
Time being will not be possible. On request made on behalf of T. Chakraborty, Learning Council for the petition. When do you want?
There is some administrative matter because actually I am to put to Sakar Malad, I am not getting my salary Malad for the post which I am holding Malad.
When do you want?
Next week Malad.
Except 28th.
28 Malad.
28th will not be possible for us.
Okay, 3rd December.
Obliged.
21.
May I please, Your Lordship? This case relating to selection of president and vice president in terms of guidelines dated 27/6/2010, but responded authority violating the guidelines forwarded 2 names that which I have challenged.
Affidavit has also not come.
Nothing.
Then how is it coming for the hearing?
They did not interested.
No, who is appearing?
Government appeared. Government types appeared. The amount to admission they violated in Asimbanu's case, Lordship.
Secondary education?
They are not interested. Every occasion they appeared. They never paid for time to file a affidavit. Private respondent also not filed. They know it has violated the guidelines. May I, specific guidelines, may I please, Lordships? And then how they have violated their own guidelines by pick and choose basis, 2 names forwarded. Guideline is at page 25.
1 minute. Interim order has been vacated.
Interim not vacated, not continued.
That means vacated.
Actually not vacated, not continued at the interest of the schools. It was challenged before the division bench. Division issued notice, thinking on the returnable date prayer will be considered, but delayed. Thereafter it was disposed of. The matter will be decided by the learned single judge.
So this order was not interfered.
Nothing interfered. Main issue has to be interfered.
Yes,
See, any other day, probably they are in other court, one council is present. So last time,
last occasion it was 1B Kaushik.
So Lordship, if last item, then Lordship may fix in Monday, Lordship, I will inform them.
Monday.
Monday is not a hearing then.
Then Lordship, Thursday or Tuesday, Lordship, I will inform them.
Majumdar, you are appearing in this matter? Kaushik is no, Katani.
Thursday, no, Tuesday, fix to know.
No affidavit has come, it has been fixed for hearing.
Lordship could have it on Tuesday, my lord, I'll have my. This matter appears. This is a, as far as I remember, my lord, this was a minority institution. Their managing committee is somewhere under issue.
Is
There
the
was-
issue,
no, no.
issue of
It is
is
provincial
the
school.
issue of the
It's clear.
president of the SMDC.
Indiology has to do.
Yes, India, but
School,
West is the minority, but
There was a.
Heard if you Barboya, then the council for the petition.
appeal to the close
On request made by Mr. R. Majumdar, then it's
It
nothing
has come
council.
up, but I'm just interrupting, I'm sorry, my lord. It has come up for hearing because the appeal was, that is where I had appeared. The appeal was disposed of and matter be heard of at an early date. So therefore it has come up on the hearing list. We are yet to file our appeal. It should be on the admission matter.
No, no, no.
No,
It's not like that.
earlier occasion.
9/10/2023.
Earlier, prior to that, it was
Order says writ
List.
petition be listed for hearing.
hearing, prior to that.
That I missed out. I was in the division bench matter. I had.
A division bench, there are the directs also, and the single bench also.
Kaushik was appearing all through.
His. Or should we have another next Tuesday or Thursday, my lord? I'll have.
Okay, this
I'll have
one,
the file for.
28.
20. Lordships.
Yes.
22.
Lordship, in this case, you're supposed to file an additional affidavit, your Lordship.
You are supposed to file.
Yes, your Lordship. Yes, we will file because what I have been informed by the petitioners that from the annexure 7 that the regularization order along with the list of 193 teachers, some one or 2 or 3 persons got adjusted in the year 2021. So want to bring into record all these documents before the final disposal, your Lordship.
Then it is in the hearing stage, no?
Yes, your Lordship.
How can we permit you to file your additional affidavit?
Otherwise, we have come to know of late, your Lordship. This
Who appears finance?
finance has filed their affidavit, your Lordship.
There was a huge exercise of regularizing some of the persons by the education department.
Hmm.
My lord, my friend here is saying that people have been.
Yes, your Lordship,
regularized.
because what I have verbal communication.
People has been regularized. People.
Okay, MS
Yes, that's good.
S. Dasgupta and counsel for the petitioner. Praise for?
Actually, from that side, Borakvali side, train communication is closed for the time being. So if it is posted in the month of December, that because parties will come and do their affidavit, your Lordship.
Press for 3 weeks' time.
Yes, your Lordship.
To file an additional affidavit. Press allowed. List on after 3 weeks.
Much obliged.
Finish.